Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil may Anglican police, verbal public. Oh, for Trump's sake.
All right. I think I'm ready. I think I'm almost ready. So I'm sitting here at my desk this morning, wondering, why am I hearing myself? First of all, let's fix that. There it is. Okay, we fixed that. Okay, so I'm sitting here at my desk this morning as I'm getting ready to go live. I'm looking at the clock and seeing the seconds count down. And I'm thinking, I think I'm ready. And I'm ready to reach for the live button. I look up and my camera is not there. My camera is not there. I'm like, I still have my camera put away from yesterday. We took it on a little field trip. But welcome, it's here now. We're up. Sorry for the delay. I'm back. Welcome to Friday. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you here today. It is a No Pants Friday for sure.
I apologize.
It was terrible. It was a terrible start. I apologize. But we're going to kick it off anyway. We have a few things to talk about today. I think we're going to do a little car chase action from yesterday. We were live streaming the Airbnb special on the channel. A car chase happened, and then we had to leave and do our own car thing, so we didn't become our own car chase. And yeah, it was, well, I guess it happened in the other order, but anyway. Either way, morning is here. It's Friday. It's the weekend. It's podcast day. We have a car chase. We have a couple things to talk about in the legal world that are very interesting, specifically with Bryan Kohberger. So we want to talk about those as well today. We have some updates. I know a lot of you with me joined Dr. G yesterday for his live stream and had a great time there. Watched some great questions, some great input. He's just an incredibly insightful person. I really like him. A good friend of the channel as well. So if you have anything from there you want to share, I will tell you that I never would have guessed that Dr. G was an Ultimate Fighting fan. So I thought that was just my guilty pleasure that very few people shared in common with me. But Dr. G also likes to watch a good fight occasionally. So that was cool. We've got crime cons going on, I think, still down in Florida. Brandy Churchwell's there. A couple of the people we know from various other court cases, including prosecutors, defense attorneys, specific prosecutors who play the guitar are showing up there. So if you're on social media, I'm sure you're seeing pictures of all the famous people from the crime world down there hanging out and having a good time. So that's there as well. Anyway, the weekend's here. A storm is coming, which actually, if Weather Watch is here, Mrs. R.A. is not happy about, because we had plans to go up to Yorktown. And basically, our driving commute is following the eye of the storm from where we live, where it's going to hit us, up to Yorktown. And then we'll be coming down as soon as it clears out of Yorktown. And so that's not good. That's not a good situation.
GHX for the prayers. All of you have my heart red hard.
Krista, thank you very much. I have not seen, let's see. Let me catch up where we are here. Hold on. I see Krista's here. Let me before I find out what's happening here, and we've got some birthdays and everything else. Let me first bring this up. Right. Oops. As I dump my water over. Good thing it was not open. Let's see. Wait for it. Connecting. It says connecting, but it's not connected. There we go. All right, first things first, we have to do this one right here. Angelica with a J. I realize you're a new supporter on the channel. You're a new member.
I was kicked back, taking it easy.
Maybe you didn't know. But being first in chat is it comes with a prize. We'll call it a prize just for the time being. It comes with a prize. First in chat is the person who's like broken the ice and dove into the water and said, "Hey, everybody, come on in. It's fine." Joining me in chat. You did that today. You were first in chat, which is no small accomplishment. It is a feat to be celebrated, and because of that, we are going to celebrate by awarding you ownership of the internet. I believe this is a first-time offense for you. I mean, first time you've won. Pardon me, I just a little slip of the tongue there. But in addition to all your other duties that you're responsible for today at home, online, at work, if that be the case, you now also are responsible for maintaining everything internet related worldwide. And so thank you and good luck. Congratulations on your new win. Love that you were here first in chat. Thank you so much. Let's see. We have Krista says, "Thanks for the prayers. All of you have my heart." Krista, I didn't see. I'm way behind. Let's see. Here it is. Oh my goodness, cousin having brain surgery. Thank you everybody for reaching out and support for Krista. The thoughts and prayers. That is wonderful. I appreciate that. And Krista, you're in a great community of friends that want nothing but the best to happen for you and your family. So our thoughts go to your cousin.
Bring the jury.
All right. Hopefully good news soon on that one. Let's see. Happy No Pants Friday. We need to do some birthday celebrations.
Don't miss the forest for the trees.
We'll try not to do that as well. I see we've got Kay Scarpetta. Is there anyone else who has a birthday to celebrate? I guess we could say between now and Monday.
No, and Murdoch stole it.
Between now and Monday. Alex Murdoch this week said he was going to plead guilty to some federal crimes. Federal financial crimes. Surprise! Plead guilty. They were not expecting that. They were expecting a fight all the way up to the end.
How does he do that? Okay, I'm looking for birthdays. Let's see.
Aaron sees 80s Music Man. Did he sneak in?
He's the guy.
Because he's the guy. That's how he does it. Yes, we saw the guy that walked out of the hospital getting captured. Well, we didn't watch him get captured, but I saw that come across my feed online on Twitter or X. Used to be Twitter. I still don't know what to call that.
All rise. Court is now in session.
Hello, Creative Bee. Welcome. Good to have you here. Let's see. Is there anything else? I don't see any other birthdays. I think I'm good. I'm scrolling.
I'm not a camel.
Thank you, RA, for this amazing community. Met so many great friends. You are amazing. Tropical drink. Much love and support at Krista High Voltage. Sign, my girl.
I like the Krista High Voltage sign specifically. Krista, lots of support. And Dinah Do 420. Thank you so much for that. I appreciate that. You are a one of the great ones around here that makes it the community what it is. It wouldn't be the same without you. Thank you, Jamie Latorno. Happy anniversary to us. Thank you for all you do. Happy anniversary. 5 months. 5 months. I assume that's the one you're talking about. If otherwise, let me know. Okay, so Kay Scarpetta. Is Kay Scarpetta in the house? Ready to be sung to? Appropriately celebrated? I think it's just Kay Scarpetta. You might get a solo just for you if this is the case. All right. Going once, going twice, and sold. Oh, wait, hang on. BBE cat and animal lover. I'm blessed. Birthday 25th of September. Okay, so that's Monday, right? So we can sing to you on Monday. Will you join us on Monday? Let's see if I missed anything else. SOS just gifted a membership. Thank you very much. That went to Sherry Smith. Congratulations, Sherry. Where's the buffer sound? Okay. Gil Gillipud. Can I just say Gil? Because I'm not going to be able to fit all this in. If that works. Okay, so we've got just those two. Okay, here we go. La 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 la. Warm-ups are the key. Warm-ups are the key. That's why it happens. Happy birthday to you. Happy birthday to you. Everybody, happy birthday, Gil and Kay Scarpetta. Happy birthday to you. I appreciate everyone joining me on the chorus there. That was wonderful. I guess it's all chorus, right? Gil and Kay Scarpetta, thank you very much for being here. Happy birthday. Have a wonderful birthday. I know there are a million places you could be on your birthday and places that would celebrate your attendance wherever you go. And it's not lost on me that you chose to be here. Thank you so much. It's our privilege and pleasure. Hope your day is absolutely fantastic. Thank you. Okay, Melly is more than likely going to prison. That's a fair statement. I'll stand behind that one. Let's talk about. Do we want to do the car chase first and get it out of the way? Because we've got a little bit of time to show, and honestly, it's about an hour long. We could speed it up a little bit to make it a little more exciting because it wasn't the ultimate high speed car chase that we've seen before. But let's see. Let me see if we play this at 1.25 speed. What that would do. Let's go ahead and hit play there. Let's go over here for a second. 1 second. I'm getting there. Speed. We're going to do 1.25 speed. How about that? It's going to be a little more exciting this way. So we have a car chase. This happened yesterday. Northeast Torrance is where they're at. We'll see if we can bring some audio in as the helicopter right now is just looking for him, right? This is how it starts. Are there any turtle shells? John K., welcome to the jury. Thank you so much. Good to have you as a jury member. Welcome. Look at this. Here we go. We've locked in. Helicopter's locked in. Interesting thing about this, they appear to have some sort of flag or banner. Is it like it's a Bob Marley? It gives me like a reggae set type feel. Is that a country's flag? Is that Ghana? I don't know. I don't know what's going on here. But they've got a banner out the sunroof or zipped into the sunroof. And they're hauling, even though it looks like they're going faster. They're really only doing about 60 miles an hour, and they've got cops behind them. It's the hey, look at me flag. Yeah, it's the hey, helicopter. In case you miss us, in case we actually do evade the police, here's how you can find us again. We'll go ahead and put a bright multicolored flag on the top of our car so that you know exactly where we are at all times. Now, during this chase, there's a couple things you have to watch for. First of all, it's going to be, let's see, it's 25% slower, so it'll only take 45 minutes. We're going to shave 15 minutes off of that. But somewhere in here, there's a handoff. There's like a throw something out the window to a waiting passerby, which we need to watch for.
Last
because
time we saw a pursuit where there was a flag out the window like that. This person driving.
Yeah, when have we ever seen a flag out the window like this?
Because he's the guy.
We're going to keep the audio down for a minute and just watch the chase. I might go up to 1.5 speed. Are we okay with 1.5? Is the national flag of Lithuania? Could be soccer hooligans, says 6-Volt Bus. Let's see. Let's go up to 1.5 and really make this a dangerous chase. Hopefully they're still safe at this speed. Boom. Here we go. Now we're cooking with fire. Oops. There we go. Okay, lots of lane changes and everything else. We're going to keep this going as we talk about the events of the day. Let's see. He thinks he's in a race. It's Das Autobahn. It's the Autobahn, of course. He's going slow for the Autobahn, I think, at 51 miles an hour. His problem, though, is not the car. I think the car can handle higher speeds. The problem is he's in traffic. And this was yesterday afternoon, early afternoon, and it could be that he's. Let's see. Is it a robber? Who said that? It was a robbery suspect in a stolen car. Okay, so generally when it's a robbery suspect in a stolen car or when it's somebody in a stolen car, they have little regard for the well-being of the car. As far as scrapes and scratches and dents, they're more open to receiving those and not having a problem about it. This is the downside to many car chases. In most cases, you're stuck on the roads, only so many places to go. Heather Davis brings in some options for what the flags are. Let's see if we get a close-up again. Let's see, she's got two of them here. Let's see which one. Does seem to have something in the middle of the yellow. I can't really tell. We'll have to watch a little bit. Yeah, there's nowhere you can go. You're going to either run out of gas or run into traffic. Those are the two options that happen, and they happen to people who just are on the regular commute. Honestly, just headed down the road, you're probably going to run out of gas or run into traffic at the same time. Michelle Phillips says, "Hey, Recovery Addict, love the Airbnb. Glad you took the step to get legal." LOL. FYI, my current hubby is a code inspector. All right, yes, we are doing everything legal with the Airbnb. The last thing we'd want is have a non-conforming, isn't that what they call it? A non-conforming addition on the property, which basically means at any time the city could come by and say, hey, you have to tear that down, and that would be bad. That would be very bad. Could be Lithuania. Now he's moving 70 miles an hour. He's cruising here. This was yesterday because the sun is barely coming up now. You're correct, Ronaldo. This happened yesterday afternoon. There's a close-up of the flag. Looks a little bit tattered, like it's been up there for a long time. I wonder if they know it's there. They probably know. Do you think it got stuck there? Oh, no. They definitely know about it. They're cheering or making sure it's flapping appropriately. This is sort of bizarre. A couple more votes for Gryffindor. Maybe Bolivia. I don't remember. Ooh, whoa. Look at that. Somebody else tried to cut him off. Did you see that? That little minivan? Little minivan almost cut him off ahead of him. But now he's in the fast lane and zipping along there. And I think this is the carpool lane. So hopefully he's got a second occupant with him. Otherwise, that's just one more offense added to the long list of offenses when he does eventually get pulled over. We're going to turn up the sound just a tiny bit, hear what's going on. There's going to be talking fast, though.
Of traffic in different parts of Southern California as we talk about the backups at any time on a Los Angeles freeway. This lane obviously is open,
the backups at all
going
times
to narrow down
on
and
Los Angeles
merge
freeways.
eventually, and the suspect is going to have nowhere to go but be stuck in that traffic.
Well, we're in the carpool lane right now, the express lanes, which you can either pay for or you have a second passenger. It was tough to tell, but it looked like when the person was holding that flag, may be a passenger in that vehicle. That hasn't been totally
he's
confirmed
legitimately
yet,
in
there may
the
be somebody
carpool
else
lane.
sitting up there in front. It certainly looked like that to me as this person drives.
What I think is funny is there's a guy ahead of him that's just like cruising. He's like, I'm going to ride this as far as I can.
Now the speed is picking up for this person in this express lane.
Look how many people are not able to go in the express lane.
Could also be the flag of Ghana, as we're trying to figure out what that flag is representing.
So Ghana, a vote from Ghana from the news crew.
How this car was taken, from whom, by whom? Do they have a cell phone number? Are they in contact with any kind of relatives or friends? Going on behind this, but clearly somebody's willing to keep this pursuit going. Knowing police.
Let me update you a little bit on the non-conforming addition is a no-no. The unregistered car where we're at, we went through our paperwork and we found that last year when we were supposed to register the car, we took it in and we did the required inspection, which it passed, and we paid for the inspection fee. And previously, where I've lived in other states, when you take it in for the inspection, it renews the registration as well. It just wraps it all into one big fee. I guess that was a mistake on my part, because I also found an unopened email in my email box that said that my car registration is due and should be renewed. So my bad. We're getting it inspected again because it needs another inspection. That should be done any minute now. And then we're going to, hopefully, if it passes inspection, then we can go and pay taxes on it. And then once we pay the taxes, then we can go to the DMV and get it registered. Sure. No, I've got the paperwork. We saved it for this very reason. I'm like, our inspections are free in New Jersey. Do they hold up in North Carolina if we're going to do an inspection there? Flag could be Senegal. Could be a Senegal flag, I guess. I don't know my geography and flags. It looks like a Jamaican or something. It's got the colors: the black, the green, the yellow.
this is Slauson here, where they could potentially get off, but doesn't look like
being a green Mercedes. It could be the driver from the Embassy of Ghana. It could have diplomatic immunity. I wonder if he'll play that card here when the whole thing comes to a stop, which it will. I've heard it does come to a stop.
Today here on Fox 11. In the meantime, we're watching. Christine, as we just talked about, there is that part of the 110 freeway where the express lanes go over the rest of the traffic. That is what we are looking at now. We've now reached that.
Now he's look how far ahead he's getting of everybody else. It should not take 14 days to find this guy. I think they're going to keep him in sight. The helicopter's not going to get away. What are we covering today? We're going to talk about a couple things. Bryan Kohberger is the first one, and I guess we can do that while this car chase goes on. I'll just turn the volume down a little bit. Bryan Kohberger, we hope we should have footage today from a Bryan Kohberger hearing, and this has been something there's been a lot of confusion about. See, hang on, there's something about my car I needed to read. Now you just take it to inspect, then go to DMV and handle tax registration at the same place. I thought that's what we did last time, but I guess I missed a step. Anyway, Bryan Kohberger, the big deal that everyone was waiting on, that everybody is just really anxious on, is that the judge has been asked to address an issue of cameras in the courtroom. And realize we're talking about Idaho here. Idaho, the same place where we just had the Lori Vallow trial, which in that case the judge ruled that cameras were not allowed in the courtroom. And the audio only would be allowed, and that even that would be delayed until the end of the day, and then it would be released. And so it was an audio only release. It was a mess. It was really, really bad. Very difficult to cover for those who wanted to cover it. And it was awful. I love that all Brandy's mods are in here today, or at least most. Yes, we've got so many of them. As Brandy's in CrimeCon, which we wanted to talk about, she's been posting some great pictures. So let us know in chat what your favorite pictures Brandy's posted are. This is not live. This is not live, Maisel. This was last night. This was last night during our Airbnb tour. This happened. Anyway, the judge in the Lori Vallow case rules that no cameras are allowed, that it's audio only. It's going to be the end of day, and then on top of insult to injury, okay, to make things worse, their fee for getting the copy of the audio is ridiculous. It's super high. It would. I think if we did the math on the calculated length of the trial, it was like $3,000 to $5,000 you'd have to pay to get copies of the audio late, which was not good. So what we saw was all the media who normally compete for information. You want to be first, right? You want to be the first to air with something. You want to have the exclusive. The media got together and said, "Hey, we're not gonna play this game. We're all gonna pool our money, pool our resources. We're going to order this, and then we'll share it with everybody. Everybody gets it at the same time, but we're only going to pay them once. We're not going to let them get rich off this." And that worked a little bit. But with that in mind, and that's the history that we've seen out of Idaho, we now have, and that case has actually, I think, been referenced in the Bryan Kohberger case. Now we have Bryan Kohberger also complaining about cameras in the courtroom and accusing Court TV of the same thing that happened to the Lori Vallow case, that they're zooming in on him. They're filming just him, and it's invading his like personal space and makes him feel unsafe. Sort of like the 4 people that he allegedly murdered, I guess. Sorry, I shouldn't go there. But either way, he's got these rights that he says need to be defended, and he doesn't have a fair trial if there are cameras right in his face. That's his argument. They're also worried that the jury is going to. Well, that was a quick little move, a little exit there. I wonder if they juked the police out, or nope, they're right on his tail. Anyway, so he's also worried that the jury is going to be biased because of the coverage and everything else. And the judge is worried about what other people are going to do with the video footage that comes out of court. He's literally concerned about people who will Photoshop the pictures into, put horns on Kohberger or make his eyes look glowy red or something like I did that. Okay, so he's concerned about that and wants to see if you think he's orally musing about stopping people from doing that. Which he could do. All he'd have to do is just find enough support in the nation to get away with the First Amendment, and then we probably could do that. But really, he's just spinning his wheels. Anyway, sorry, Debbie. A little fired up about this. This issue makes me so frustrated because I don't know. I think the public's right to see what happens in court goes above the victim's right to not have the public see what happens in court. I think when it comes to justice, when it comes to administration of justice, it should be open and transparent. Anyway, so we're still waiting on the judge to make a decision. And he said he will make a decision, and he's said he's probably going to compromise. It'll be a compromising decision. Hopefully the compromise isn't between the First Amendment and access. Hopefully the compromise is between what the defense has said they want and what the media coalition has said that they want. So obviously Media Coalition would be just fine with maybe 6 cameras in the courtroom and everybody mic'd up. That would be great for them, for the media. We're not going to get that in this case. We're not going to have the multi-views and the different angles, and we can cut back and forth. And we're probably going to have a fixed camera or one that's mounted at the very back of the courtroom, and maybe a second camera if we get lucky, and then we'll get some courtroom audio. Hopefully it's good. So we're waiting for that decision. But today, that decision, we're not expecting that today. That can come at any time, but we're not expecting that today. Today, there are 2 hearings that Bryan Kohberger's team has filed. And let's see. So I'm getting updates. I want to make sure it's not something I'm missing. Yes, I did mean to say defendant's right, not victim's right. Victims do have rights. They're somebody who got pulled into this on their own. Defendants also have rights. I'm not mitigating that, but I think at the point where the court has determined that there's enough evidence to proceed, I think we've passed the point where it's like we haven't just dragged someone off the street and accused them of something that they're not accused of. There's no reason to believe they did that. I think there's enough evidence that when we get to court, we've gone past those initial hearings, we've found that there's sufficient evidence to proceed to court. I think it's open to the public at that point. I'm sorry if I said victims right. I was completely wrong. Victims do have quite a say in this. All right. Do all us addicts get a coupon or a discount on your B&B? I don't know. We still don't know when we're going to open it to Airbnb or how that's going to work. We need to see the demand for the nurses, which is what we built it for primarily, and then we'll weigh in on that. Allie B from Tennessee says, love this channel, 5 months. Thank you, Allie B. Thank you so much. I appreciate your support. Let's see. We've also got another one here from, Amy, H51, also 5 months. Thank you for the emojis, Amy. It's been wonderful 5 months. Looking forward to many more. I appreciate you being here. Wouldn't be the same without you. I've got my window open and there's a very loud truck going by. See, Emily D. Baker had a great point on that he could curb all the speculation and conspiracies simply by televising the trial. Yes. And this was brought up to the judge. This was a great argument. This was brought up to the judge. Basically, the judge says, I hate that everyone is spinning this, taking these pictures and spinning it out of control with all these theories that are, in some cases, they're wrong. And the coalition, look at that guy. Look at the dude that just cruised by the police chase. Did you guys see that? He did 100 miles an hour past the police chase and oh, oops, sorry. Just realized there was a string of cops behind me. At least they're after a different guy. Anyway, the coalition basically said, Your Honor, if you want speculation, if you want inaccurate reporting, if you want wild conspiracy theories, just go ahead and close the courtroom and see what you're going to get, because then nobody has the truth. Nobody has that definitive truth to base everything off of, which would be the video record of the occurrences as they happen in the courtroom. And I think that was a powerful argument. Now the guy's going slowly. It's like, I didn't know there was a police chase. I was just speeding to work. So I think there's a very good argument to be made there, and I think that weighed in on the judge quite heavily, and he's considering that. Hopefully he also considers the fact that the freedom of speech allows people, even if there is full camera coverage with great audio live out of the courtroom, broadcast from sea to shining sea, that it's still okay for people to go out and make crazy conspiracy stories, that as long as they legally are not breaking the law in how they do that they can be completely wrong in their videos, and that's all right. That's one of the beauties about the freedoms we enjoy. So hopefully the judge isn't too caught up on the people who will be wrong and would be wrong anyway. Anyway, so that's going to happen. The judge today, though, I keep trying to get to the things that's happening today. Today there are 2 hearings. The first one is going to be closed. The closed hearing, meaning it's closed to the public, not just to media, but it's closed to the public, and this is going to address issues revolving around the grand jury. The defense has said, they filed a motion saying we want to dismiss this grand jury indictment. And grand juries are done in secret, so it makes sense that the the ruling on this part is also going to be in secret. But they have a list of reasons why they want to dismiss this indictment. They say, they say, first of all, it was a biased jury. There was inadmissible evidence. There was a lack of sufficient evidence, and prosecutorial misconduct occurred. So they're throwing all these things at the case, and I don't think any of them are going to stick. I think what we're going to have is a judge that listens. Judge is going to listen politely and hear the arguments from both sides, and then he'll promptly say denied, because this process that was followed is one that is done very, very carefully, and the objections that Bryan Kohberger has are dating back to like the 1800s. They literally they're taking something out of context from way back in history, saying, you should have done it this way, the way it was done in 1827. I don't think it's going to fly. I don't think it'll fly at all. But the second hearing, which is a separate hearing, which is open to the public, and we believe there will be cameras in, that hearing is also about the grand jury, but it's a little bit different. On that one, the hearing is saying we move to dismiss because the grand jury, in their instructions, they received an improper instruction. So it would basically be equivalent to the judge at the end of a case telling the jury, just for an example, if for some reason you're not able to reach a conclusion, you should all vote guilty. That would be wrong. That would be an improper instruction that the jury received, and they would have to rectify that somehow. So Angelina Knox says, all right, good morning. We're here in Michigan. I don't have the inspections thingy. Yes, several states have gone away from the inspections, and some of them over huge protests, saying if we don't have inspections, we're going to have just any rattle trap contraption vehicle that can somehow navigate down the road out there, and it'll be unsafe for everybody. It really has not proven that way. The states that have gone away from inspections, it hasn't caused that, and most of those unsafe vehicles are already illegal even without the inspection. So I think they could still fix the problem. Technical Farmer says, right, it's a public trial. We should all see it. Maybe we all need to go to Idaho and pack the court and demand that it's held in a larger venue so the public can see it. They have a very small venue, and that's not a choice thing. It's just they're a small county. They're a quiet little town in Idaho. The venue is small. They will have to have some sort of capability to let other people participate, because I don't think even just all the victims' families who might want to be there, as well as the media who just has the right to be there, and the locals who have the right to be there, as their tax dollars are spent prosecuting this, they're not going to fit. And then you add on that the national interest that we've got people from coast to coast that are interested in going, myself included, and there's no room. It will be a fight to get in the courtroom, and many people will get no sleep the night before if they do get into court, because they'll be in line. People have been drawing on published photos forever. How many mustaches have you drawn on a newspaper or magazine photo? Maisla, yes. Modifying existing artwork is the name of the game here in the United States, and it's fun, it's funny, and some people do it for a meme, some people do it out of boredom. But for the judge to say that this is a problem, I think is wrong. I don't think those modified images, are convincing to persuade people that... Oops, something's going on. I don't think they're convincing to persuade people that the actual modified document is the real series of events. I think people can see through that. Let's see, where was the buffer? Bryan Kohberger hearing to dismiss indictment postponed by illness. Both of them? Sharon? We've got lightning bolts in chat here. Let's see. Okay, so if that's postponed by illness, maybe during the spare time, we might be able to have the judge address the camera issue then. You got a call? Car's ready? Oh, we haven't got a call yet. You want a call? I don't think I've received a call yet. I have not.
You haven't, but it's been 2 hours. What are they doing?
I don't know. Charging us money and driving our car around, I think. Okay, we're still waiting for the car. This driver's had a lot of close calls. Yes, look, it gets worse here. I mean, this guy's just weaving in and out of traffic. I've heard that people don't like this. Like if you're a regular commuter stuck in traffic, you view somebody like this, not just the fact they're running from the police, but the fact that they're using the emergency, the shoulder on either side of the road to get by. That's really frowned on, and people like to crowd you out if they see you in time. Kitty Cat says, "I'm going to try one more time." What did I miss, Kitty Cat? Did I miss a comment? BK got pushed back into October. We are trying to take a break from some of the children cases. We do them occasionally, but they are very hard on the community. I will say that Mrs. R.A. And I had a conversation this morning about, can we rethink the Maya case? And is that something that we can do? The Maya Kalowski case is going on right now. It is a civil case, and that might be a little bit different. And I honestly, I pulled it up to check and see if the way that things are presented might be in a manner that's okay or oh, is this it? Is this how it ends? Are we there already? Nope. He's still rolling. He's just debating. He's playing with the cops. He's like stopping and then getting out, stopping. Who needs the buffer sound? Somebody said I need a buffer sound. Lauren Farmer says, if I text you the video, will you watch a hilarious body cam video? It's so funny. Lauren Farmer.
If I text you the vid, will you watch a hilarious body cam vid? It's so funny.
It has to be straight from the police. It can't be from another channel. So if another channel aired it, it has to be no markings, nothing on top of it. Oh, he's looking to cut across. Man, this is crazy. Okay, somebody says they needed a buffer sound, and who was it? Texas is doing away with inspections next year. Driver's really animated here. Let's have a listen, see what's going on. Oh, their mics are off. He's all over the place. What is he doing? Whoa. Is he in a physical altercation inside the vehicle? Is that what we're seeing? Is he throwing something out the window? Or was he trying to reach something in the back seat? What is it, like a map? He was throwing stuff out. He is alone. Man, he's very, very animated. He's all over the place in that car seat. And not buckled up, I might add. Rolling with 7 says, I just want to watch the case I just don't want to watch it without my family. We'll have to weigh in a little bit because that case, he's in panic mode. The case has some tough issues that we would need to basically not have heavily present in chat. That presents all sorts of problems for us on the YouTube end. Do a poll. Okay, just got the text. Let me check the body cam footage. Let's see what it is. I can make no promises, unfortunately. I'll try, but let's see. There's the body cam. On March 19th. Oh man, it's got a watermark and speaking over it. Let's see, where's this at? Wisconsin. It's got both the watermark, which I can't play.
Driver just getting his MapQuest directions organized, grinning face with squinting eyes.
It's a MapQuest. Man, this guy is... His lane's disappearing. He's got cars on both sides of him. He's just squeezing through. Ooh, ooh, ooh. It's not going to fit. Not going to fit. Couple questions for you on the Maya case. I was watching this morning because it began early this morning, trying to find out what the schedule is for how long it's going to go, because we are behind a few hours. I think we're about 4 hours behind on that case. We can catch up. We could do that pretty quickly, but let's put it to a poll. Does that work? Let's see if we can do this.
Why the flag though? Face with tears of joy.
The tears of joy. I'm not sure what he's repping there, but he intentionally opened the window and like spread the flag out. So he's got something. He's got something to say. Okay, we're gonna ask this. Just when you go when you go and think about this answer, this case has some allegations of abuse, which I believe were proven false, or were that's my understanding, and it also has it centers around the fact that the mother in this case, after being accused of abuse and having her daughter taken from her, ended her own life. And those are the main facts about this case that are difficult. So we're gonna put this poll out there and see how you guys feel. And we'll have to catch up as well because we're about four hours behind. I realize this community is able to handle a lot and work together on a lot of things, but I don't want to make it miserable for anyone to be here. It will be hard. It'll be a hard case, but I mean we've got some hard cases coming up with police officers involved. We've got some tough things, and it is a civil suit as well, where we have the benefit of having different rules, different standards of evidence, different thresholds that need to be met. It's a very different case than a criminal suit. Nancy Deer says, would like to keep up with the Frankie case. Nancy, we can follow the updates on that, but I'll tell you, I would be very, very surprised if that case is aired in court, because they're living child victims, and that's the crux of the case there. Maisla, in this case, the family, or the daughter, who is now an adult, is suing Johns Hopkins University and the doctors that alleged the abuse and caused the separation. Jag, I'm not sure if his goal is to get away or to just get attention. I think, yeah. When does the Tacoma case start? That one starts October 2nd. That's with the 3 police officers. That's going to be a tough one as well. So we've got a couple big trials, and then in the middle of that, possibly Sarah Boone is going to happen as well. Here we go. Too many choices. He's at a crossroads in his life and he doesn't know which way to go here. Let's see. Whoa. Was that a handoff? Was that a handoff? That was a handoff if I've ever seen one. Something just got thrown out of the car and somebody received it. And I think the police are after them. Yeah, that guy's going to be busted for sure. He threw something to that other guy. It was pretty slick. He was stalling for the guy to get to the corner, I think. He wasn't waiting for which direction he was going to go. He was stalling to get to the corner. Oh, up on the curb. Now he's desperate. Now he's making a run. Now I think he's trying to get away. Before he was not trying to get away, but now he's really just trying to put distance between him and the officers. Getting a little tight in there. A little scary. Does anyone know what he threw out of the car? Have we heard any reports of what that was? Whoa. Oh, look at this. Look at this. Gray truck saying, I'll have none of it. He's blocking the path. It's a game of chicken. And he pins him in. He's pinned. He's pinned. Wow. The police will tell you not to do that. That gray truck now, the gray truck is right down range from this. So, yes, they want this guy stopped, but the police might. Look at this. Look at all the hand gestures. No, stop, go, this way. The officer's trying to get traffic from behind this guy out of the way. And forgot how to use the door. Here he goes. Oh, man, he's stuck. The belly. The struggle is real here. His pants appear to be caught on the window. He's losing them. He's stuck. He's trying to get out, and he's stuck. I shouldn't be laughing, but this is why you have a belt, my friend. He's like, I can't. I'm right here. Somebody help me. Somebody help me. He's hooked on the... His legs are like flailing on the inside. Someone's going to have to just drag him out. He's like, I'm trying to raise my hands, but I got to hold myself up. I've got my hands up. They're just, my head is down. That's the problem. Did something just fall off of him? I'm not sure what just happened there, but he lost his bling. His necklace. Oh, here he goes. Here he goes. Are his feet tangled up in the flag inside? Tag says the worst high-speed chase since the gas dude, the guy who was huffing not nitrous oxide. He flags his car and forgot to grab his pants that fit him. He's like, look, can I just open the door? This guy, I'm going to say drugs might be involved. And he does a roll. Look at that. Roll and sticks the landing. Pants are almost down to his knees. I think the guy in the gray truck is just hunkered down in his truck, just laying down. I didn't see him ever get out. The cops are laughing like, all right, now who has to go up there and help this dude out?
This is a mess. LOL.
It is No Pants Friday, so it is appropriate. Good call on that one. Latex. Very compliant. Very compliant. I think the officers are, at this point, they're not sure if there's another person in the vehicle. So they're probably going to stack up, maybe get somebody with a shield and stack up and move up to the vehicle and make sure it's safe. Somebody's running to get a shield.
I love the scores, 9.5 for the dismount. It was the roll. It was the roll that did it. He's done this before.
9.6 out of 10.
It's a little high, Cachette. It's a little high. You're being generous. Officers are still running around trying to get everything secured. A lot of vehicles are clearing the area as much as possible. The guy in the truck did get away earlier. Okay, so he's out. That's good news because he's right. He's the backstop, basically. His vehicle's the backstop for their firing range. I don't think any shots are fired, but Topsail Guide, good morning. Been a minute, but lighter meetings today, so happy to join you. That's awesome. They've got less than lethal. I see the stun gun or the shotgun that fires less than lethal beanbag rounds out there. No stack, no shield, but they've made sure the vehicle's safe, and now they're going to secure the suspect. If the guy in the truck dies from laughter, would it be involuntary manslaughter? There we go. And now he's mouthing off. Now he's running his mouth. And struggling. He's resisting here. Dude's got a piece to say here, and he's letting him have it. They're going to search him before they put him in the car. That's what they're doing now. Doty says, saw the guy in the gray truck get out and run. That's the wise move. It was not smart to hem him in. I commented when this happened live on the news station. I commented just in there, and I said, I'm starting a change.org petition to bring pit maneuvers back to California because I think Arkansas has it right. Maybe they take it a little too far in Arkansas, but they do the right thing and bring the chase to an end. There's just so many people that could be injured in something like this as the longer it goes on. But that was crazy, and they're trying to figure out what the flag is and what's in the car. But good job, Gray Truck. You win the internet tomorrow. How about tomorrow? Because we already gave it away today. We gave it to Angelica with a J. Thank you very much, Angelica, by the way. Okay, we're going to go ahead and end the poll here on the Maya case. And we're looking at 75% are in favor of viewing that. Dinah says, I'll sign that one. Points off for mooning. It is sped up. It is sped up, Allison. We watched this. This happened last night actually I was doing an Airbnb walkthrough for y'all on the channel for a little Airbnb we've been building. Yeah, so this is going to wrap up right there. I think the helicopter is going to clear out, and they're done. Great way to kick off the Friday for everybody except for one driver and possibly a passenger or a pedestrian who is in possession of something he shouldn't have. Something he shouldn't have. Let's see. Stark-Hair Rottweilers effort 10 out of 10. Awesome. Love the picture. Love the Rottweilers. Can we watch the rollout again? Says Maisla. I can try to get there. Give me a second. We'll see if we can. Okay, the rollout. There we go. Backpack. Okay. Here we go. Here's the rollout. First, he loses his bling. That was his necklace, I think, that came off. And the way it dropped, it looked like gold. I'll tell you, it looks like he's wearing some serious bling. Okay, he's stuck. He's hung up on the door.
That awkward moment when your own car performs a stop and frisk. I believe he is congratulating the officers on their proper arrest procedure.
Yeah, he gets searched by his own car quite effectively. Okay, give me just a second. I looked down and I missed it. I have to back up. Hang on. We're going to right here. 5538. One more time. He tucks the head down, arms, rolls, hands up with the victory formation. That was pretty good. I can see where you give the 9.5. I definitely see that. So that was not bad at all. All right. All right, we're gonna do this. We're going to attempt to catch up on the Maya trial. Add this to your opening video, says JBC. We're going to attempt to catch up on the Maya trial, which means that we're going to give this a try. If this gets too bad, we would bail on it. But I realize it's an important case. It's a civil trial. We don't watch a lot of civil trials. I think that because of that, it will be a little bit different. And possibly better in that regards. Let's see. Let's see if we can catch up here. Now, if we are catching up, we're going to have to watch it a little faster than normal. So let's see. Playlists. So we have 3 hours and 23 minutes of yesterday's video to view.
And I'm going to destroy them. No one, including me, will ever review your notes. If you do take notes, please do not get so involved in your note-taking that you become distracted from these proceedings. Your notes should be used only as an aid to your memory. Whether you take notes or not,
I'm going to turn the speed down to 1.25.
And you should not be unduly influenced by the notes of any other juror. Notes are not entitled to any greater weight than each juror's memory of the evidence. During the trial, you may have a question about these proceedings. If so, please write it down and hand it to the court deputy, who will then hand it to me. I will review your questions with the parties and the attorneys before responding. Please put your juror number on the question, but do not put your name. And the juror number is the one that the clerk gave you and that we've been using over the last few days. During the witness testimony, you may have a question that you think should be asked of a witness. If so, there is a procedure for you to request that I ask the witness a question. After all the attorneys have completed their questioning of the witnesses, if you think you have a question, go ahead and raise your hand. I will give you time to write that question on a sheet of paper.
Okay, so that's important. The jurors get to ask questions. I'm going to speed this back up again because
do not put your name or your juror number on the question that you have for the witness.
Because these are instructions.
I will go over those questions with the attorneys. Under our law, only certain evidence may be considered by a jury in determining a verdict. The jury is bound by the same rules of evidence that control the attorney's questions. If I decide that a question may not be asked under our rules of evidence, I will tell you that. Otherwise, I will direct the witness to answer the question. The attorneys may then ask follow-up questions if they wish. And then, if there are additional questions from the jurors, you can then ask those additional questions. And we will follow that procedure until all the questions are exhausted. Now, by providing you this procedure, I do not mean to suggest that you must or that you should submit written questions for witnesses to answer. In most instances, the lawyers will have asked all of the necessary questions. So members of the jury, we went about 30 minutes, and that completes my instructions. The next thing on our agenda is to do 90 minutes of opening statements. Does anyone wish to take a break now, or are we ready to proceed for opening statements?
He asked the jury if they want to take a break. That's nice of them. Okay, so here we have the...
on Zoom, I'm sorry I didn't have that mic open, but it's open now. I apologize. Okay, so we are all good to go for the next 90 minutes? Mr. Anderson, you have the floor, sir.
The girl there in the picture, I believe that was the daughter that was taken from the parents. And she's suing. So she's sitting here with her lawyers.
Plaintiffs will prove that from July 7th, 2015 through January 13th, 2017, Johns Hopkins missed a diagnosis of complex regional pain syndrome on 7 different occasions when Maya was entered their care. We will prove that they misdiagnosed Maya's symptoms from October 7th through the end of the year, wrongfully accusing Beata and Jack Kowalski of child abuse, and alleging and attempting to show that Maya had a mental disorder. She was crazy. She was making it up. We'll prove that they realized their error pretty quickly. And instead of apologizing, saying we're sorry.
Wow, there was an objection. Can we approach? Early on in the opening statement, there's been an objection. We do have a pan-tilt zoom camera in the front that's going to give us some great views during the proceedings. That's actually seated. The camera you'll see if we see the judge. It's right in front of his laptop or right next to his laptop. Meg, I have not seen the documentary on this one, so I'm hearing this like the jury does.
Continue, Mr. Anderson.
Upon realizing their error, for the next 3.5 months, they took every step in the world to attempt to force the Kowalskis to agree with the wrongful diagnosis. Maya Kowalski was falsely imprisoned and battered. She was denied communication with her family. She was denied communication with the outside. She was told that her mother was crazy. She was told by social workers that one in particular, she would be her mother. She was put into a room and left for 42 hours with the commode just out of reach because the hospital wanted to prove that she could actually get up and walk. So they wanted her on video, this is a surveillance room, to get out of bed and then go over to the commode when nobody was watching. Instead, she defecated on herself. For 42 hours, she was kept in that room, denied access to anyone or anything, under the false assertion that it was an EEG exam. Maya was repeatedly battered by nurses and social workers who were trying to prove that she did not have CRPS. Things were done such as coming in and patting her on her leg. They were hugging her against her will, took her down to the chapel, sat her on the lap of one named Kathy Beatty, who told her that she would be her mother. Her mother was, crazy, and that she needed a mother, and that social worker would be there. Maya was kept from her family and friends. She was denied access to her priest. She had what they called religious artifacts, such as holy water, her prayer book, her rosaries taken from her on the belief that her mother was controlling her over religion. She was denied access to counsel, at least insofar as having the ability to actually meet with her attorney without people listening in at the door. All of her phone calls were monitored. Her iPad, computer were taken away because she was told she might be, this is a 10-year-old, cruising internet sex sites. Maya was denied the comforts of her friends and her family throughout her stay there. On another occasion, again, to try to show that Maya did not have rather significant symptoms of CRPS, which you'll see are these small little red, angry lesions that appear on different parts of the body, underneath the arm, along the arms, sometimes on the legs, sometimes on the back. And you'll see photos here in a moment. But in order to prove that she didn't have one, she was systematically stripped and photographed against her will, and without any authorization from anyone, least of all her parents. They continued to accuse the Kowalskis, Jack and Beata, of being child abusers, even after the evidence, we believe you'll conclude, was overwhelming that she had CRPS. In fact, we will see whether at some point they even admit she had CRPS in this case. Yet they still, throughout this period of time, continue to accuse Beata of child abuse and Jack of child abuse, something called Munchausen by proxy, which means that you're intentionally trying to keep your child ill. It's usually a circumstance with a very small child where a mother will be like putting something in an IV or things like that. And Maya, at this time, was 10 years old. There's no evidence whatsoever of Munchausen by proxy. By January 13th, when Maya was finally left out of the hospital, unsurprisingly, this family was a wreck. Maya was not let out of the hospital even after her mother committed suicide on January 7th of 2017. Now, the story with Beata Kowalski is a complex one, and I'll tell you about it in a moment. But we will prove that the continued allegations that she was crazy and that she was trying to harm her own children, both Kyle and Maya, and the knowledge of the systematic abuse of her child in the hospital caused her, at the end, to lose completely and utterly her ability to control the maternal instinct, and that outweighed the survival instinct. In the process, they caused Beata Kowalski her life, denied Jack a loving wife, denied both Kyle and Maya a loving, caring, and amazing mother. They cause just terrific and permanent psychological injury, as one may expect, a permanent aggravation, and we'll explain the medicine behind that, of the CRPS. Now, the CRPS didn't start with Johns Hopkins. It started about 3 or 4 days before Johns Hopkins. But the evidence will show that something that could have been a controllable, manageable disease was aggravated to the point where, throughout periods in her life, she will be incapacitated. And through all of it, she and her brother and her father will have post-traumatic issues and problems that will, frankly, we'll get that into that in a moment. We've asked, in this case, for you to consider not only compensatory damages to try to make them whole for these terrible things that have happened to them, but also punitive damages to deter them, to punish them, and to deter this type of behavior in the future. So some of the evidence here will be directed towards that. So that's the overview of what we're trying to do. Now, how are we going to do it? First, you understand that we have really 4 plaintiffs here. We have Maya Kowalski right here. We have Kyle Kowalski, and we have Jack Kowalski. And Jack's also the parent guardian of both of them, right? So the claims go through him. And then he has independent actions himself. And he's also appearing for the estate of his deceased wife, Beata. And each of them have causes of action, some of them combined. Now, this historic case has been going on. It was filed in October 2018. I tell you this because the key facts in the case began several years before. But through the course of time, we've taken an immense number of depositions. We have found audio tapes, videotapes, surveillance tapes, a lot of evidence for you to review towards proving these allegations. The core claims, again, are medical malpractice, which is that the defendants failed to meet the standard of care, and we will prove that through expert witnesses, that they failed to identify CRPS, which is also known, by the way, as RSD, it's the older name, reflex sympathetic dystrophy, now known as CRPS. Okay? They failed to identify it at first, and then they misdiagnosed it, and then once misdiagnosing it and realizing they misdiagnosed it, the evidence will prove they went about a system to try to get the Kowalskis to admit they were right. Battery, I talked about. False imprisonment of Maya on multiple occasions. Intentional infliction of emotional distress is where you do things so outrageous that they cause damage and injury to a person. In this case, a suicide. In this case, traumatic disorders, depression, a multitude of emotional problems and issues. We've alleged fraud in that they intentionally deceived or attempted to deceive in the proof of the matter. We also alleged fraud in that they billed $536,000 for the treatment of CRPS, and yet never treated her for CRPS, and took multiple positions, especially to them, especially to Maya, that she did not have CRPS. Yet they billed over $500,000 to the healthcare provider and Kowalskis for the treatment of it. Beata Kowalski was born in 1973 in communist Poland. You may recall that the Berlin Wall came down in 1988, and in 1990, within a couple of years, she was able to escape Poland at the age of 17 and come to the United States. She also had a couple of relatives here already, so she made it over, stayed with relatives in Chicago, and got her AA in nursing, and then her BS in nursing, and then added to it 2 or 3 other specializations. And then eventually, and we'll go to this in a moment, ended up an infusion nurse. Jack Kowalski was born in 1961. At the time all this went down, so Maya, Beata would have been 44 and would have been 50 today. Jack is 62 at this point. Jack was born and raised in Chicago, was a firefighter and paramedic for over 28 years, rose to deputy chief, one of the Chicago fire departments. He donated time during the post 9/11 recovery to help. He also worked during Hurricane Katrina during the recovery effort. And we'll have some video, I think, about several saves Jack made, one in rather dramatic of a wall collapsing right after he got some people out of the building. For 9/11, he designed a license plate for 9/11 firefighters, the loss, that's, I think, still in use. And he insists on distilling what he further insists on calling wine, which you will not have to try through the course of this case. That was a joke. Well, I'm sorry. It's just not.
He distills wine.
Jack and Beata met in Chicago, and they were married on a cruise in Jamaica in 2004 with friends. Beata became stepmother to Jack's daughter Corinne by prior marriage. They were married, like I said, in 2004. They got along tremendously. There was a lot of mutual interest, one of them scuba diving. Jack was, as we say, a firefighter. Beata was a well-trained nurse working for Loyola University Medical Center in the cardiac catheter lab. Maya was born in 2005. Beata began working for CBS Coram as an in-home infusion nurse, which gave her a little more flexibility in terms of raising a family. And then Kyle was born in 2007. Interesting story there. Kyle was born with thrombocytopenia, which is low blood platelets, And because they needed blood, Beata's blood specifically, but because she had just had a child, she could not give the blood. Beata got up, checked herself out, went to a hospital down the street, gave the blood, collected the blood, came back to the hospital, checked herself back in, and gave the low platelet combating blood to her baby son. The couple moved to Florida in 2014. They already had some family down here. One of Jack's brothers lived here, lived near them. And Jack was able to retire after, I think, 25 years in the fire department. And Beata was able to transfer positions down to CVS Coram. And she developed and had wonderful patients throughout the area here. Jack started applying to become a FEMA representative using his experience as a firefighter. That plan, as we'll see, was interrupted by what happened here. Maya, growing up a typical healthy kid, she had some asthma and allergies, as a lot of children do, but nothing that wasn't controlled with the usual. She enjoyed ballet, gymnastics, figure skating with her mom. It's a very big thing in Poland, figure skating. And so Beata spent a lot of time with Maya towards that. And then Maya and Kyle enjoy fishing in the backyard. Now, Kyle has majored in being skinny for most of his life, although we're finally seeing him put on a little bit of weight, loves fishing. And the new house in Florida they had over in Stonewalk, is that right? Has a pond out back, which is very handy. Now, on July 3rd, 2015, and this is a photo of the July 4th party, Maya started to feel a little bad. She apparently twisted her ankle in a gymnastics accident, or just doing gymnastics, I guess.
The audio's clipping
and then,
pretty badly.
On the 4th, during all the festivities, Maya simply collapsed on the floor of the kitchen, and I think you'll hear Uncle Bob, her uncle, say she made a noise that no human child should make. And almost immediately had extraordinary pain, which developed over the course of the next 3 or 4 days to the point where it was extremely difficult for her to even walk. This was completely mysterious to everyone. She also had extremely rough coughing fits, which we'll have some, I know we'll have audio of, may have some video of too, so you can see where these came from. These were from deep within. She was taken to the ER, and then the initial diagnosis was allergic reaction, reactive airway disease. There were multiple theories, but Maya was not getting better, and on July 6th, there was her first inpatient admission to Johns Hopkins. Now, at this point, Maya could barely walk, and she was brought in, testing done. Of course, the parents and her brother are going nuts because they cannot figure out what's going on with her, and she is complaining of being in extreme pain. And so Beata, the nurse, gave a full history of everything she knew to that point, which really wasn't much because it had only been a few days. Johns Hopkins really didn't have much of a diagnosis at that point, although they thought maybe some of the steroids that Maya took from her asthma might have been, causing some reaction. So her first consult with Suzanne Jackman from Johns Hopkins notes low cortisol level, muscle pain, and muscle weakness. Says the pain and weakness may be steroid-induced myopathy. And by this point, Maya, by July 12th, was discharged in a wheelchair. So she came into Johns Hopkins the first time, walking with difficulty, left in a wheelchair. And the diagnoses at that point were secondary to steroid use, generalized muscle weakness, habit, cough. Steroid myopathy is interesting in this case because I think one of the issues may be about the amount of ketamine it all eventually took to control Maya's pain. And something I think you're going to find is that steroids that she takes for her asthma actually have a component that breaks down ketamine pretty readily. We'll get into that a little further and have some experts talking about it. And Maya, like every victim of CRPS, had good days and bad days, but her legs continued to wither. The second admission was July 17th through the 20th, an inpatient admission, again, to Johns Hopkins. There's a history and a physical, presents due to even more increased pain, now moving from her legs to her arms, her back, her stomach, her neck, and head. The differential diagnosis, myopathy, myositis, and now we start in with psychological pain conversion because they cannot figure out why this child has this degree of pain. In other words, no clue at this point. So, as part of the treatment, they suggest that Maya be taken somewhere else, TGH, Tampa General Hospital, for therapy. They thought maybe physical therapy would help the child. And as part of that transfer process, they sent Maya's history and physical notes to TGH, and then had a phone call informing them that they thought this might be conversion disorder, this might be mental. So the first time any of these other doctors heard anything about Maya Kowalski, it was with an initial possible diagnosis that it was all in her head. The child couldn't walk, and certain symptoms were coming to the forefront by this point. Now, because Johns Hopkins couldn't figure out what the heck was happening, Maya was taken by Jack and Beata back up to Lurie's Children's Hospital in Chicago. Now, this is her former home. It was a familiar place. Lurie's had treated Maya for this asthma previously. They thought, well, let's take him back and get a second opinion. And so, and Johns Hopkins was aware that patients were going to seek a second opinion and contacted and talked to them about their theories. The doctors in Chicago couldn't figure out what was going on either. So Jack and Beata proceeded with Johns Hopkins' recommendation to take him to Tampa General. Again, the doctors in Chicago thought, well, it could be steroid myopathy, it could be generalized muscle weakness, or maybe it's all in her head, but nobody made a diagnosis of that. She went to Tampa General Hospital, and TGH, as I said, already had Johns Hopkins records. Now keep this in mind. Facts will show they already had the records. They already talked to them about what Johns Hopkins thought. All right, so Maya had inpatient comprehensive pediatric rehab and physical therapy and occupational therapy for the steroid myopathy. Now the reason this is important is that there are certain treatments that you get for CRPS before you start ramping up on some of the medicines that are used. So you want to see if the most basic types of therapies can bring somebody around to lower it to the point where it's
well, he's talking for a little bit. This clearly is, this case is going to have a lot of heavy medical info, and the few of us, I'm not included in that group, understand every word that's being said and know what they're talking about. I think the majority of us are going to struggle with exactly what he's talking about. I will say this: I have not watched. Let me turn the sound off while we're watching. I have not watched the Netflix documentary on this. I've just heard little bits of this. I will say that my gut impression, just going into this, my gut feeling, is that if everything is as the complainants are saying, if that happens exactly like that, and there's no evidence to the contrary, this would have been settled out of court. This civil suit, if it was a slam dunk civil suit, it would have been settled out of court, and it would have been resolved a long time ago. So clearly the fact that the hospital has gone to battle in this one and gone to court and risked the public image and everything else, there's going to be a side that they want to present as well. So I'm going to reserve judgment and listen for that.
Conversion disorder versus factitious disorder versus others, anxiety disorder, myalgia. Now, importantly here, you'll see that it says resolved by admission. But we're going to bring in the actual physical therapist that treated her. And you will find throughout this case, the facts will show that there will be a distinct difference between what the actual people who were hands-on treating Maya had to say about how she was doing and whether she's progressing, and what was put down in the medical records. The Tampa General Hospital visit was very difficult for her. At this point, she was displaying what is known as dystonia. Dystonia is where the ligaments in it could be anywhere, but in this case, in her ankles and feet, were contracting to the point where her feet were starting to turn in like this. This is a clear indication of CRPS. Tampa General Hospital thought that maybe they should put some boots on her and see if that would correct her feet turning in. And we'll have some video from the physical therapist that shows Maya attempting to walk in those boots, Maya attempting over and over again with things like trying to push her leg and saying, "Giddy up, horsey." Again, remember, it's a 9-year-old girl. And demonstrating she was trying as hard as she could to walk. The evidence will show throughout this, Maya did not want to be in a wheelchair. She did not want to be one of the kids that was looking out the window while all the other kids were playing. But Maya kept getting worse, not better. And she was still in pain. And when school starts in 2017, 15, she said she was still in pain throughout her body, and she would moan and scream in time in panic. And she kept getting weaker, and weaker. Now, Maya was in and out of Johns Hopkins throughout this period of time. Okay? And there was prescriptions for opioids, again, physical therapy, occupational therapy. Nothing was working. No one had any answers. And then a patient of Beata's, one of the infusion nurse patients, said, this may be CRPS. I have a daughter with it, I believe. Why don't you look into seeing this? And there are doctors here in Tampa Bay area that are specialists in this. And so she went to see Dr. Anthony Kirkpatrick at the RSD Foundation, Reflex Sympathetic Dystrophy Foundation. Now, to diagnose complex regional pain syndrome, the Budapest criteria for CRPS gives us certain specific symptoms, diagnostic criteria. Persistent burning in the arms, hands, legs, feet, or another part of the body, check. Multiple medical records will show she had that. Pain can be mild or severe. We have actual audio recordings of Maya moaning. You'll see and hear the child and can determine whether or not she was in pain. Swelling, sweating, all of those. Dramatic changes in skin color and skin temperature. Testimony is that Maya was constantly too hot or too cold. Now, people get too hot and too cold all the time, but usually they're not 9 or 10-year-old children, to the point where they're either shivering and need a blanket, and then 2 hours later are wondering, why is it so hot in here? That kind of temperature change. And of course, then blurred vision, which is already appearing in the records, dystonia, again, the movement disorder like this, and then a really confusing symptom called allodynia, which is an extreme but often inexplicable sensitivity to touch. It means that on some occasions, you could come up and squeeze Maya's arm or touch her legs and get no reaction at all. And at other times, just the thought of someone coming up to her and putting their hand near her as though they were going to touch her would give off an incredible reaction, screaming, yelling, resistance to anyone even touching her. Reason? That because of the RSD, CRPS, she would feel extraordinary pain as a result. But it doesn't happen all the time, and it doesn't mean that when you don't have it, you're not in pain. One of the experts will testify that this is sort of like, think about it as a cancer patient or someone with an intermittent disease. You may be in remission and be doing fine and look fine to everybody outside. You may be hurting like crazy on the inside, but outside you look pretty good. And then other times you may be curled up in a fetal position and not be able to walk, talk, or move. Also a light sensitivity. Interestingly, the Budapest criteria, which are kind of the accepted criteria for CRPS, are also listed by Johns Hopkins as their diagnostic criteria for CRPS, right? So she goes and sees Anthony Kirkpatrick, Dr. Kirkpatrick, who you'll meet. Now, notice on the photograph, see the feet there turned in? Notice the lack of muscle mass on the legs. She's in a wheelchair, obviously, and that's sort of a attempted smile, but she's got sunglasses on. Now, why is a child wearing sunglasses inside at the doctor's office? Because she has a sensitivity to light caused by the CRPS. So Dr. Kirkpatrick went over the entire full history, list of symptoms and therapies tried. He did objective testing, including pain threshold test, range of motion test. We'll actually have videos from before and after where you can see that before the treatments she eventually had, are part of the issues in this case, she could barely get her arm up to here, and then you'll see after the therapies that they ultimately complained about, that she can put her hand completely over the other side. And the diagnosis was CRPS. Now, Dr. Kirkpatrick did not say, all right, let's just go into some heavy duty pain meds or anything else. Again, he said, let's try some physical therapy and what's known as warm water therapy, which is essentially where you use a very warm pool or bath or something and you do it in there to loosen up the muscles. A little different, but again, physical therapy. He did not recommend out of the box any sort of pain meds. That didn't work, and that's when he introduced them to a revolutionary use of an old drug called ketamine and the ability to break the chain. See, CRPS involves a problem in the pathways between the pain sensors of different parts of the body and the brain. Usually, when someone injures themselves, you sprain a finger or something, ow, it hurts like heck. But over time, right, it starts hurting less and less and less, and pretty soon after a while, you just kind of forget about it. That doesn't happen with CRPS. Because of a problem as yet not understood, which is why we don't have a cure, the pain relay, the circle, the loop here of feedback is getting bigger and bigger and bigger, until what was once a tiny little fracture or a tiny little sprain or whatever you want to call it turns into something that is the worst pain known to medical science. I'll talk about that in a moment. And ketamine, which has been around since the 1950s, it's FDA approved. It's used mostly as an anesthetic, and it's not an opioid. It doesn't work like an opioid. But for some reason, not fully understood, it breaks this feedback loop and people start getting better. Not all of them, but a very high percentage get better. So there's actually, I think, do we have the audio on this? So this is one of the initial visits with Dr. Kirkpatrick discussing the use of the ketamine infusions. And I want you to concentrate on what this mom, who's also a nurse, is asking about.
Who in your practice administers the ketamine?
I do.
You do, okay.
And I'm ACLS certified also. I have to take.
Yeah, you have to be.
Well, PALS, you got to have the PALS and all that stuff. And we have a pediatric code card back there. You know, we have to do all that stuff if we're going to do
good.
children.
Absolutely.
Yeah.
That was my next question. Do
you
you have a pediatric crash card?
No, we have to. We have to.
Yeah.
You know, I mean, that's a standard of care. You have to.
Now, Beata knew all about how to keep her daughter healthy, not this disease, but how to keep her daughter healthy and how to protect her daughter. And notice in there, one of the first things she asked about, is there an ACLS crash cart? Are there all the different equipments that you might need, even during an infusion, because remember, she's an infusion nurse, in case anything could go wrong. Now, here's the McGill pain scale. This is interesting. I had no idea until I reviewed this. But, this right here, as you can see, this goes over, and this was developed in Australia. It's been around for a long, long time. It's adopted by about every hospital, every medical association. And this describes the different pain levels according to description by patients and every other objective finding that one can make. And you'll see at the top that CRPS is the most painful. It was actually developed at the University of Montreal, Canada, by Dr. Lasco, I guess. And most of the clinical trials were, I believe, in Australia. Symptoms of CRPS, we've gone over those. It strikes mostly females in the population between the ages of 7 and 21. It is known for initial symptoms that are inexplicable. However, upon close review and a differential diagnosis to rule out other things and consider neurological disorders, this is one of them. And if you can identify a few of these symptoms, our experts will say CRPS should have been brought into the mix very quickly. That did not happen here. All right, so from October 6th through 8th, she has her first ketamine infusion with Dr. Kirkpatrick, a follow-up, and the first infusion went well and helped to get Maya out of pain, and there was a lot of encouragement over that. He wasn't pushing for more ketamine. He's simply trying to instruct on a conservative approach, warm water therapy. Let's try the ketamine again. They tried it again, and again, got some good relief, but not for very long. Maybe for a week, 10 days. But not what they were looking for, to bring this child back to being a normal kid, right? So, at this point, Dr. Kirkpatrick says, well, she might need more and frequent of these infusions, so why don't you go over to Johns Hopkins and visit for a PICC line placement? And so, on November 4th, she goes back to Johns Hopkins for a PICC line placement, and the diagnosis over there accepted is CRPS. And so Johns Hopkins itself does the PICC line. PICC line is it's basically a tube that's put in so you can do the infusions a lot easier without trying to find a vein. All right, so, and she begins therapy because, again, everybody wants to find out, is this really anything exaggerated by Maya? Is there a psychological component to this? Let's just make sure. So Maya starts with a therapist by the name of Rebecca Johnson, and I believe you'll hear from Ms. Johnson or Michelle Rogers, who is her partner there, about those. Maya was never determined to have any type of conversion disorder or factitious disorder by any psychiatrist or psychologist, except that as part of CRPS, there can be certain symptoms of conversion, which is, how do you explain this? The feelings of pain become so exaggerated, this allodynia, that the patient is anticipating pain before it actually happens. So she goes and has the therapy, but still nothing is working and nothing is really getting her out of the extreme pain on a long-term basis. So Dr. Kirkpatrick, and you'll hear from Dr. Kirkpatrick here to explain all of this. Unfortunately, in the United States, the procedure that had been shown to work the best for intractable CRPS, long-term ketamine infusion under general anesthesia, a medical coma for 3, 4, 5 days, is not performed in the United States. It's performed in Germany. It's performed in Mexico. It had been around since approximately the 1990s. It had essentially 100% rate of safety, that is, no one had ever died from it, and it had a very high rate of success. There is a physician, University of Texas trained anesthesiologist, Dr. Fernando Cantu, who's going to fly here from Mexico to describe the process. And it involves, again, infusions of ketamine over a very long period of time, the idea being that it causes the brain to reset so that you don't have this feedback loop causing the pain. The first one, in late November, 19th through the 23rd, there is a high-dose infusion, and what do you know? The lesions begin to heal, and there's a slight less turning out of the feet. And yet the pain was still not where they wanted it. So Maya stayed there, and then on November 19th through the 23rd, she went through another high-dose ketamine infusion. Now, during this period of time, other than during the middle of the infusion process, there were absolutely no negative signs from Maya. She had a brief increase in her liver function results, but only, we're talking for a matter of hours. And as soon as the ketamine infusion was done, they went right back. And it's important to note that other than at that time, and through all of her ketamine treatments, Maya's liver functions, which is the things you look at if you've got a medication like this and you want to see, is it hurting somebody? You look at the liver functions, and her liver functions have stayed normal throughout. And you'll see the medical records to show that. All right. So then, a miracle. By December 28th, Maya's lesions are noticeably less. Her feet are starting to not be as turned out. In fact, by the end of January, and we'll show you the films, she's actually able to get back in the pool. You can see a picture of her here in, I believe, late January. And this is her. You'll notice the feet looking better. She's on Kyle's shoulders there. You'll notice a real smile coming up. She's able to do her warm water therapy. But she still is having some pain. And the idea here was to get this kid out of the wheelchair, right? They wanted to get her out of the wheelchair. And to get her out of the wheelchair, they really needed to get the feet totally back, and they needed to get the pain levels back so it wasn't so painful when she walked, so she could build up her legs. That was the idea. So they go back to Johns Hopkins, okay? All right. Central port means there's an operation, and there's the note. Placement implanted central venous port. That's a tube under her arm to allow her to continue high-level fusions. Not like Mexico, but outpatient procedures. And she has a number of them through the course of the next 9 months. Through the course of this, and with a doctor named Dr. Hannah, who Dr. Kirkpatrick recommended, Dr. Kanju recommended, because frankly, ketamine is incredibly expensive and it's not covered by health insurance. So Dr. Hannah was set up to do these on a regular basis. Oh, yeah. Oh, I better get going. Okay, so Maya goes back to Johns Hopkins, and Dr. Anthony Kreisman, who had seen her before, the long-term ketamine infusion, quote, ketamine coma, and had commented on how withdrawn and how much pain she's in. Listen to what he says on May 11th after about 30 of these infusions and the long-term infusion. She is a completely different child from when last examined. By that I mean she is not in any pain, she is not moaning, she is smiling and interactive, she is very engaged. She moves spontaneously in her wheelchair without incurring pain. Through the course of that summer, because the ketamine is so expensive, they tried 2 other therapies. One's known as hyperbaric. You can see it right here, extreme high oxygen content, which has been known to help some CRPS patients. She also tries the IVIG treatment to increase her immune system because it's believed that CRPS can be, the immune system may be part of CRPS. And by the end of the summer, she is almost back on her feet. This is in 2016, around August of 2016. Maya is almost back on her feet. We have video of her actually using that as kind of a jungle gym to try to strengthen up her arms and her legs. Everyone is very excited. Everybody is looking forward to Maya getting on her feet. And then she has what they hope to be a minor relapse that turns into a fairly major relapse. And she goes back and has larger ketamine doses with Dr. Hannah on October 5 and 6. And she has some gastrointestinal problems and a lot of pain in the midsection. There are stories that you'll hear about her screaming at night. She could not take the pain in her stomach anymore. At one point, the screaming was so intense that the family got a walkie-talkie, so the family could stay all the way over on this side of the house and Maya over here because no one could sleep. So they communicated by walkie-talkie. All right, so they decided on the 7th, October 7th, a key date, to take her to Johns Hopkins ER. Now, the reason was that we had Hurricane Matthew tracking up. If you if you've been in Florida long enough, the hurricanes start to blur together. I believe it's Hurricane Matthew tracking up the eastern seaboard here, getting winds like, 35 to 50 miles an hour. To people from Florida, it's like, wake us up when it's a Cat 4. But to, the Kowalskis were from Chicago and had never experienced this before. They had visions of like a movie Twister going around in their head. And so all of the ERs and everything were closed. So they took her up to St. Pete to the ER. And Maya's seen by 5 different doctors and groups of nurses and social workers from the ER. And she comes in about 8:46 in the morning, and she's crying and screaming, and she's in a fetal position, clutching her stomach, and she is just out of her mind. And the ER doctors there start to react rather negatively to this. Beata comes in approximately 2 to 3 hours later, and once again goes through the history, which Jack has been trying to relate, of all of the different visits to Johns Hopkins, and all the different treatments, and how everything has failed. And the only thing that has worked has been the long-term ketamine infusions, and we can try this, can we try that? Can we try a pump? What can we do to get our daughter out of pain? For some reason, the doctors there either review all the past records and the some 7 to 8 to 9 prior visits, and the fact that she's had surgery there to have a port implanted to help her with the ketamine infusion. But for some reason, they decide that that isn't it at all. She really doesn't have CRPS. That the mom must be making all of this up. That this is, as a nurse, who we think is the one who actually made this diagnosis, Munchausen by proxy. Textbook Munchausen by proxy. Now imagine this is an ER, the child's back there, the parents pulling their hair out, trying to explain to the hospital, this is what Jack will testify to, and Beata's trying to explain to them in an ER where they've been about 5 times before, exactly all the history that's going back, that's already in their records, including records from the other hospital. Everything's there. For some reason, the doctors, nurses, and social workers ignore all of that and decide this is not CRPS, that this is the child is making it up, and the parents are making it up, and then this must be child abuse by the parents. And the court has told you that there's pretty much a hair trigger on suspicions, and so they make the call, and that's not part of this case. You're supposed to make the call. Slightest different suspicion, you're supposed to make the call. So that's not a bad thing, whether it was right or not, at that moment. The case is about what happens after that, and the failure to diagnose previously so that none has ever happened. Maya, they try to take Maya home after the first night. They're told that they need to observe the child overnight. Fine. But by the second day, Maya is still in pain. They do knock her out with a lot of drugs to get rid of the initial pain. And they give her ketamine. So the next day, she's much calmer. And so then they decide that Maya cannot go home. They decide that taking her home is AMA, against medical advice. And they say, if you try to take your daughter home, we're calling security. So the Kowalskis don't have much choice. They end up leaving. And the next thing they know, they're off for the races and Maya is an unbelievable journey up through and including the death of Beata. Now, what you'll notice in the records, again, the records paint a glowing report of Maya. Just how great she's doing, how much she enjoys things. What a great stay she's having. She's getting this, she's getting that. The only thing she was getting to do was play the piano. Maya knows how to play the piano. She got to play the piano, and she got to draw pictures. Every once in a while she could send a letter. If she wanted to talk to her mom, it had to be on a supervised call. She could only see her dad and her brother on pre-arranged and monitored situations. If she wanted to see her attorney, obviously. If she wanted to see her attorney, the nurses would demand that the door stay open. She never had a private moment with an attorney. They're Polish Roman Catholic, which is about as Roman Catholic as you can get, and have a very close relationship with their priest. So the priest went in to see Maya, and he will testify that when he arrived, he was told that he could not see Maya, and that she had had her religious artifacts taken away. We have a photograph of it. And he asked about this, and they said it's because we believe her mom is controlling her through religion. And so he was not allowed to see her that day. And it took a few other attempts, and then finally he was let in, but he was told, no religious procedures. You come say hello, no religious procedures. I told you already about the 42 hours of being placed in a darkened room and told, this is a new type of EEG, Maya. We're gonna really figure this out if this is in your mind or not. No, it wasn't. It was the surveillance room. And again, the goal, because these doctors had somehow gotten confused to think that CRPS includes paralysis. Paralysis is not part of CRPS at all. And yet, they were trying to prove that Maya could actually get out of bed, that she was faking it, that she was sitting in that wheelchair all the time, just, I don't know what reason, but she was faking all this. It, actually, when nobody was watching, Maya was getting up out of that chair and walking around everywhere. So they put the commode just a little bit out of reach, right? Figuring, when she thinks nobody's watching, she'd get up and she'd go to the bathroom, go over there. Well, that didn't happen. And you'll see video of Maya having to be carried over to the commode. Of course, her skin started to show the lesions again. Maya started on a dive. Badly getting worse. Depressed. The lesions are forming. You'll see them. Here, now they just may look like scratches here, but you can't see too much of the stuff on the back. What you'll notice through the series of photographs, and thank goodness Dad here took photographs of Maya's lesions, and you'll see those photographs, and I want you to compare them to the medical records, because you'll see on the dermatological reports, you'll see skin normal, and yet you'll have photographs from that day showing lesions. On January 6th, they decided that they needed photographs to prove that Maya really didn't have as many lesions as they said. So they brought someone else in, and we have better pictures. You can see a little bit of Maya's face there. They claim, oh, this didn't bother her at all. There was no authorization from the family, no notification to the family. Maya was screaming bloody murder not to do this because it hurt. They took off her clothes except for her training bra and her shorts, pulled down her shorts, pulled up her shorts there to take photographs of her. Now their testimony is, oh, this wasn't bad on her at all. She was fine with it. No, what she's told is, if you don't let us take photographs, you're not going to see your mom. That's what they told her. So they end up taking photographs, and somehow, where are the photographs? We've only got a few. We do have photographs from the father at the time, however. So by this point, it's pretty bad. Let's talk just briefly about Beata. During this period of time, Beata is only allowed to talk to her daughter. Hopefully we'll be able to play some of the tapes where we'll be able to hear Beata trying to talk to her daughter, but they put certain things off limits, like, how are you doing? How is your treatment? How is your medication? Things like that. No, you can't talk about that. Not allowed to talk about that. They're the most mundane things you can imagine on these telephone calls. We are allowed to use them. And in those, you'll hear one of the social workers, Kathy Beatty, who was assigned Maya. Now, she was a social worker from one floor, but wherever Maya went, Kathy Beatty followed. And we have the trail of emails and notes leading from notification to the general counsel, through risk management, on down to one of the senior doctors, down to Beatty, about doing this stuff, including what you just saw there in the photograph. We'll prove they knew it at the highest levels. Beata is going freaking nuts, the evidence will show. They find out that Beatty's had some disciplinary problems. They find out, kind of through the grapevine, how bad things are for Maya. They find out about the lesions. Now her feet are completely turned in. And Maya has become so weak, the CRPS has developed to the point where she can't sit up straight. Okay? Now, on the evening of January 7th, Beata, they were going to a party. Jack and Kyle were going to a birthday party, I think. And Beata had been not acting herself at all for a number of days. And she didn't want to go to the birthday party. She didn't really want to go anywhere for a long time. The only thing she did was go to work. She was withdrawn. She and Jack had been having screaming fights because Jack did not want her to be so absorbed in this. He was more of the, let's just try to get her out of there, work her out. And Beata was trying everything. Legal, social, every possible way to get her child out, and her child was not coming out. And she found out through several sources the condition that Maya was in and what was happening to Maya. And on that evening, once they were out, she decided to take some belts and put them together, go out to the garage, make a noose, put a stand below her feet to be able to reach it, She took an IV of saline solution and put the IV in her arm and left a cell phone with a note that said, retribution, retaliation, out. And she left 2 suicide notes, which we'll try to bring before you, telling you about why she did it. It took probably about 22 minutes, according to pathologists, to strangle to death. She'd kicked the stand out from under her. When Jack and Kyle got home, they thought that she was sleeping in another room, which they did a lot, because they weren't getting along, frankly. And so nobody did that. And then Beata's brother was coming in that night. He came in and just went to sleep. Got up the next morning, walked out into the garage, I guess looking for something. And at first he thought it was a Halloween costume or something. And he looks closer and it's his sister. And he, of course, just completely screams out. Jack comes in, sees his wife with Kyle right behind him. Kyle was, I don't know, we'll ask him how much he was able to see. 911 call made. You'll hear that. And Beata is taken down. We'll have some, we're not going to get gross on them. I'm not going to try to upset you too much on the photos, but we will show you some of the photos, right? Okay. Now, after that, Jack says, let my daughter go. If Beata is the big reason here, if she's the Munchausen by proxy, why keep Maya? No. It takes another week and a half, and Maya, let me get this straight. Maya's actually told in the hospital that her mom's dead. Johns Hopkins believes it's still in her head, and there's a text that goes around about how Maya's now better off because her mom's dead. Between 2 of the doctors you'll hear testify. Finally, after a lot of effort, Maya gets to go home. Now, I'm not sure if I got the photograph on this, but I'll show you a photograph. You can see on the ride home, she's got stuffed animals underneath her, and she's slumped over like this because she's so weak she can't keep herself up. Through the course, then, 27. Okay. All right. So the hospital will now come in and tell you just how great their therapies were. We'll show you the records, and they were not doing any therapies with Maya. They were warehousing the child. Maya gets home, and with her parents' care, one other thing. The hospital doesn't want any more use of ketamine ever again. And we'll get into the details of that. So just using the old, regular, and largely ineffective pain meds, this child manages, through warm water therapy and being home with support and love, about 8 months to get out of the wheelchair. Now, folks, I want you to compare that to the time after they first learned about how to use the ketamine, how fast it took to get her ready to roll, right? Out of pain. This child does it in extreme pain. So she's on crutches here about the spring of August of 2017. Yeah, August of 2017. And it takes another year until Maya can walk unassisted. She's on crutches. One tough cookie, and we'll talk about just how tough she really is to be able to go through all this. Things go well for another couple of years, but in 2020, she has another bit of bad news about her schooling and has yet another relapse. This time, again, similar to the one in 2016, and similar, it was an emotional issue. The one right before she went into Johns Hopkins, when bad stuff happened. Pretty much the same type of symptoms, and she ends up back in the hospital, and she has to be put on a feeding tube because she's in so much pain she can't feed herself. So, fortunately, after about a week there, she was able to get well enough to come out and proceed on her way, and again had to start over in some ways, and was able to rejoin a lot of her life. Without her mother, Jack lost a wife, Kyle lost a mother, and the effects on the family are, well, we'll just have to listen to hear. Okay? So we're asking for damages for the physical injury, the overwhelming pain, not simply from the ketamine alone, but from the aggravation of the ketamine. Let me talk about this. Now, the CRPS started before Johns Hopkins ever got the picture, okay? But the evidence from every doctor that's a specialist in it will tell you that it is vitally important during the first episode of CRPS that you properly manage it in order to prevent an aggravation of the disease to the point where it's going to reappear and you will have longer, more frequent, and more devastating episodes down the road. Kenemine's nickname is the suicide disease. So the law is then that if you take a symptom, an illness, or an injury, and you aggravate it to the point where that person has a lot more pain, a lot more trouble with it, that unless some doctor can come in and identify the percentages back and forth, they're on the hook for the whole thing. All the ramifications. So now we've got long-term effects, and we're going to give you mortality tables so you'll be able to know how many years out. I'll give you some formulas on how to try to do this. I'm just an advisor. You ultimately will make all the decisions here, right? But I'll try to help with some formulas of how you can calculate such things. It's a difficult job. We talked about this in voir dire, right? All right. So we'll talk about each and every one of these. We'll talk about the physical injuries. We'll talk about, and Jack has, I haven't spent any time on Jack, but we'll get into that again on the testimony. Suffice to say, it's been devastating to not have his wife and the mother of his children. Kyle's lost a mom and the effects on him. So we'll talk about the pain and suffering, the mental anguish that you will carry around, they will carry around from not having a mother and knowing your mother killed herself for you. We'll have inconvenience. Now, you know, Beata was a nurse, so she could take care of herself, and she could take care of her family. She's not around. Loss of capacity to enjoy life. There's this thing called alhedonia, which means that you lose the ability to have pleasure out of things that once gave you pleasure. Maya tried figure skating. She won't do that anymore. Maya's not going back to gymnastics. Maya doesn't want to play piano anymore. The family doesn't want to go back to the church. And the family is having an extremely difficult time staying in the house, obviously. There's diminished earning capacity because what happens on your job if every year or two or every 6 months you have this debilitating episode where you can't work and you can't explain how long it's going to be and whether you're going to be able to do anything at home or not. And like I talked about, the aggravation of the pre-existing symptoms and the illness. So then we ask you to consider punitive damages. Our argument is this, that these actions are so completely and utterly it's designed to deter, not only here, but in the future. And it's designed to punish, right? And so your decision there would be predicated on how much money does it take if we got to that point. What alters behavior of companies like that? So, that's your job, is to figure a little bit out about this, a lot about this. And so I was trying to figure out where the defense is going on this. I think it is that from their doctor's point of view, those doctors in the ER and hospitalists' view, Beata was crazy, and they thought she was going to try to hurt her daughter. They haven't explained why. Mine did not come in with a bruise, a bump, a cut, a scrape, any bad medical tests, no bad blood work. And yet they deduced from their discussions with her over the course of a few hours that it was actually her plan. We will show you that up until this point, periodically through the latter probably 10 years of her life, Beata had had periods of anxiety, and she got treated with things like Xanax for that. And she had 2 periods of depression where she had some anti-depression stuff, never long-term and all situational to events in her life. After January of 2016, and her daughter had been through this, she sought counseling and maintained counseling to try to get through what she was going through. We'll have Dr. Tashana Duncan come in. Circumstances about her. She's a PhD psychologist who knew the story and did an intensive amount of research, and she says there was nothing wrong with Beata whatsoever. And not a single psychiatrist or psychologist is going to come in and tell you any different here. And we doubt you're going to hear anything from a psychologist or psychiatrist to say that Maya was making any of this up, or that she was suffering from factitious disorder or conversion disorder. We doubt, seriously, you'll hear that. If the defense does come up with something, listen to my cross. They say that the amount of ketamine that the CRPS doctors were using, and the fact of the ketamine, as they call it, the ketamine coma. It's kind of, in this case, that's their boogeyman. It's the ketamine coma. You'll hear one of the doctors say that that's the reason why they should be able to take Maya away from the parents. It's because they didn't think that was that was met the Johns Hopkins standard of care. So because it didn't meet their idea of how to treat CRPS, their argument is that justifies taking the child away. So what else? I think they're going to try to say that because their medical records said CRPS here and there early on and then down the road, that they were justified for billing $536,000 for a disease that they vigorously deny she ever had, and instead was always in her head. I think what they're going to say there is that, well, because some of the treatments we use can be used for CRPS, see, we could bill it. We have a memo, an internal memo, that says that they actually made a conscious decision to up their billing rate to CRPS because it's so much higher. See, CRPS takes a lot of effort to treat. You need occupational therapy, you need warm water therapy, you need physical therapy, you need psychological therapy. You've got a lot of different things that go into it. And so it's very expensive. But if you're just, evidence will show, warehousing a child while billing for CRPS, well. And you'll hear from the actual experts about ketamine infusions, why it takes so many, and what you do to determine dosage. It's called titration. Maya had pre-existing treatment by a drug that broke down the ketamine. So for what us would feel like, a Jimmy Buffett concert level of beers, to Maya would feel like 2 beers. And so that's kind of the relevance of, not a very good one, but the relevance of the ability of the steroids to break down the ketamine internally. Plus, you got to give more to kids than you do to adults. Plus, she was on this medication for about 14 months, and so there's tolerances. So the way the anesthesiologists do it, which is the way all anesthetic is done, is that you titrate up. You start on smaller doses virtually every time, and you increase until the patient has a therapeutic effect. In other words, taking them out of pain is having the right effect on them. There is no evidence anywhere that Maya Kowalski was ever in any danger. Maya Kowalski ever suffered any negative effect whatsoever. The evidence will show it is all speculation on what could possibly happen. And I believe the defense will present themselves as the saviors of this family.
You got 15 minutes left.
What? 15? Thank you. I may not even actually use it all. So, we'll lay it out. We'll bring in witnesses to tell you about CRPS. We'll tell you witnesses who spoke with Beata on her descent to the point where she felt the only way to get her child out of there, the maternal instinct was to kill herself. Take herself out of the picture, daughter released. We'll present the experts on psychiatry, on ketamine, on the use of it. We'll have the doctor flying up, the ketamine comas from Mexico. We will have psychiatrists who have studied this. We'll have the actual therapist at the time. You may actually hear from some of the doctors from the outpatient part of Johns Hopkins and some of the people that were there at the time who agreed to testify. So we'll do our very best, and we'll try to introduce video and audio and photographic evidence to document every single element of our case. So, Nick sort of serves as my walking laptop computer, reminding me of stuff when I forget it. There's much to tell you. When you've been pretty patient here listening to all of this, it's an emotional process. What we will do is try to bring you together. What you do with it is up to you. I will put on the best evidence we can. I'll have a chance to talk to you at the end. Okay? Thank you.
Okay, now the defense is going to get the equal amount
members
of time.
Of the jury, in a moment, I'm going to excuse you so you can have your morning recess. I want to remind you, you may not discuss this case amongst yourselves. You may not do any investigation and receive no information.
We're going to skip that break because we're catching up.
15-minute break. If you could follow Deputy Coley out the door, I would appreciate it. Just leave your notes in the Redwell. Thank you very much.
Skipping the break here, trying to bring you back. It's a long break. There we go.
Okay, I want to remind everybody here that's in the audience that you cannot take pictures. There is a pool photographer that the media has designated. If there's any questions from the members of the media, talk to our public information officer, Donna Rhodes, who has been in and out through the proceedings. But we do have pool camera arrangements for the media. For the members of the general public, under our rules, you're not allowed to take photos while you're here in the courtroom. Any issues we need to address?
Not that plan.
Okay. We ready to bring the jury in?
We're still sped up as we're catching up. We were
let's bring the jury in.
A little over 3 hours behind on this one. Okay, so now we're going to hear the other side. We're going to hear the defense. You've got to think they have something here, that they have something they feel is a legitimate defense, because a lot of times a big hospital like this, if they see they've done something wrong, there's proof they did something wrong, they would want to settle. They want to settle out of court.
Yes.
So unless the plaintiffs just decided not to settle at all and just refused any settlement agreement, they would have wanted to settle if they could. So we'll see how this goes. Melody, this is a civil suit. The girl on screen there, that is Maya. Maya was treated by Johns Hopkins. And
okay, everyone, please be seated.
Arguably, they say she was misdiagnosed.
Hey, members of our jury, I want to confirm while you were away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that all correct?
Yes.
That defense, it's your turn.
Good morning, almost afternoon. My name is Howard Hunter, and I have the privilege of representing Johns Hopkins All Children's Hospital and the people who staff it and who make it. We're here today to defend this case, and we appreciate the time and energy that you have put into this effort thus far. You're the most important people here. So we appreciate your attention, and we appreciate your commitment both to the trial process and to the process of waiting until you've heard all the evidence before you make a decision or begin to formulate a decision. With me today, first of all, let me introduce my team. With me today are my co-counsels, Pat Crowells, Ethan Shapiro, David Hughes. We also have today a representative from Johns Hopkins All Children's Hospital, Dr. Anthony Napolitano. See it over there. Dr. Napolitano may, or may not, wind up seeing you as a witness as well. You'll see doctors rotating as corporate representatives during the trial. They've asked to do that for the purpose of being part of the effort to defend the hospital in this matter. The hospital, after all, is not just a big pile of bricks and mortar. It's the doctors and nurses and people and professionals who run it. And so we're here representing them, although I'll be referring to the institution generally, for brevity's sake, as either ACH or All Children's Hospital. I mean, you may hear Johns Hopkins occasionally, but I've been representing them for a long time, long before they were Johns Hopkins. This is a case that has a number of different facets to it, and the circumstances and facts that I'm about to discuss with you constitute our view of the evidence. You've just heard Mr. Anderson tell you their view. I'm about to tell you ours. The judge has told you, and it's absolutely correct, that what you hear from me is not evidence. It's my view of what the evidence will show. This case involves a number of different facts that occurred over about 18 to 24 months. I can't cover all the details in 90 minutes, and if I did, both you and I would have our heads swimming from the effort. So I'm going to go over some high points. I'm going to discuss some matters that Mr. Anderson touched upon, and I'm going to ask your indulgence as we fill in the blanks over the next several weeks. This sequence of events began on October 7th, 2017. That's where the plaintiff's case against Johns Hopkins began. Before that, you're going to hear a good bit of evidence about what went before. You're going to hear about the development of Maya Kowalski's disease process. You're going to hear about where else she sought care. You're going to hear a lot about the details of that care and a lot about the problems with it. I'm going to cover some of those in just a moment. The point is, for now, that as of October 7th of 2016, Kowalski's had been to Johns Hopkins several times. They had entrusted Maya Kowalski's care to us on several different occasions. And in doing so, they had come up from their home in Venice, past Sarasota Memorial, a number of other hospitals, and sought out care from all children. Presumably, we vindicated their trust in doing that, and they came back to see us on October 7th. We had no reason to wish this family harm, and we still don't. Indeed, there's a tragic outcome in this case in terms of Mrs. Kowalski's suicide, and we regret very much that happened. The issue here, however, is who's responsible for it. And we're going to go over the facts of that and what the facts don't show in terms of any connection between what was done by all children's and that tragic result. Now, as of October 7th, we had the Kowalskis seeking out care at all children's, as I've said. We believe the evidence is going to show you that care was reasonable and necessary and appropriate. And indeed, we're going to suggest to you the evidence I'm about to discuss with you will show that what went before, the treatment that went before, did not necessarily fall into that category. Any of those three categories. And that is the reason, one of the big reasons, that we're here today. Now, as of this date, as of the time that Maya Kowalski was discharged from all children's, we believe that in fact she had been set on a path of therapy that has enabled her to resume function, to get out of a wheelchair, to be relatively pain-free, and to be in a situation of participating in her school and in society as she does today. So how did we get there? Well, on October 7th, Maya Kowalski was brought to the emergency room at all children's. As you've heard, she had bad stomach pain. She was screaming, crying, thrashing around, cursing at staff, very upset, and presenting a very challenging situation for the staff. She had pain in all her extremities. She had her whole body being said to be hypersensitive to any kind of touch. She was unable to walk. She had legs atrophied from disuse, from being in a wheelchair for months at that point, or maybe over a year. She had dystonia, alleged dystonia, different position of her feet, as you've heard, and she was demanding pain medication in large quantities. Mrs. Kowalski arrived a while later, and you're going to hear that when she arrived, she forbade the doctors and the nurses to touch Maya. The doctors and the nurses wanted to assess her, to examine her, to put on a blood pressure cuff, to put on an O2 sat monitor, to take a temperature, and they wanted to find out why there was all this horrible stomach pain. Was it appendicitis? Was it a torsion of the intestines? Was there something badly wrong that an ultrasound or a flat plate of the abdomen or a CT scan could detect? Those questions were being asked. Mrs. Kowalski insisted that before there be any workup of the child, she wanted ketamine. Now, not just any amount of ketamine. You're going to hear a lot about ketamine in this trial. Ketamine is indeed an old drug, and it's a drug that is approved by the FDA for use as an anesthetic. It is not approved for use in children, nor is it approved for use in high doses as treatment for CRPS or chronic pain. That's one of the issues here. It's not just ketamine itself, but how it was used and the quantity in which it was used. Because ketamine is an anesthetic. It is an hallucinogen. It can create dependency. It can cause depression of vital signs. If not properly monitored, it can cause serious injury, life-endangering consequences. Mrs. Kowalski on this day was challenging the staff to give her daughter a dose of 1,500 milligrams of ketamine. That is a big dose. That dose you're going to hear is several times, many times, the maximum dose that policies at all children's approve. You're going to hear experts tell you that is many times any kind of safe dose. And you're going to hear the ER doctor who was on duty that day, Dr. Layla Behar Posey, who you'll hear from by deposition because unfortunately she's no longer with us, and I mean that in this life. She'll appear by deposition, and in her deposition you will hear her tell you what she did and why she did it. And you'll hear her tell you, most pertinently, that even if she was so inclined to give that much ketamine in the emergency room where she didn't have sufficient monitoring availability, she didn't have the capacity for long-term wake-up and intubation for that period of time, she didn't have the facility she needed to do that. Even if she was inclined to give it, which she wasn't, she couldn't safely do it in that setting. Now you're going to see that Dr. Behar Posey is not just a newbie out of medical school. You'll hear in her deposition what her qualifications are. You'll hear that she's board certified in pediatrics as well as emergency medicine. She's confronted a lot of patients, difficult patients, patients in extreme pain. And you're going to hear that this patient, as far as she was concerned, had some degree of uniqueness in that she'd never seen anything quite like this, and she'd never heard of these doses of ketamine. What she found out, ultimately, and what developed over the next few days, and actually the next few weeks, is that Maya Kowalski had been given thousands, tens of thousands of milligrams of ketamine over the preceding 9 months. Her doctor, Dr. Hannah, had given her the day before admission 1,250 milligrams of ketamine. And at that time, he's going to testify to you that he told the mother he was no longer comfortable giving that much ketamine, that it was too much for him to give in his outpatient clinic. And he actually sent her to All Children's. You're going to hear that over the 9 months preceding this, that he had given her a gradually increasing doses of ketamine, 12, 15, over 20 milligrams per kilogram per hour, which is dozens of times the safe and effective dose that was approved by the hospital and that is talked about by the FDA, and that it's never been written up in the literature. You'll hear Dr. Hannah say, either by deposition or by admission on that witness stand, that this was at or near the highest per capita dosage he had ever given any patient. It wasn't working. So what had happened was that he had maxed out with this ketamine dosage. He had sent her to All Children's, and Mrs. Kowalski, despite what he had told her, despite what had happened over the last 9 months, was demanding even more. Dr. Posey heard this story from the mother. She heard how much ketamine that the mother said Dr. Hannah was giving. She heard what the mother was demanding. She saw what was going on with this child. She'll tell you what her suspicions were about the child's condition and what was actually causing it. But she called Dr. Hannah's office herself. Now, she learned that he gave 1,250 milligrams. She learned what else had happened the day before. And so she decided that she would attempt to stabilize the child. She'll tell you about literally negotiating with the mother to give a small dose of ketamine and some sedative, to conduct an examination, to admit the child to the pediatric intensive care unit. You'll hear it called the PICU. And the idea that she had at that time was, let's get her in the PICU, let's get her evaluated by pain management, let's see what's really going on here, let's get her stabilized, and then let's see if we can wean her down off all this medication she's been given. So she admitted her to the PICU. And Maya Kowalski was taken up to the PICU floor, and that process, in fact, began after consultations were placed by the PICU staff to have her see anesthesiology, pain management, and psychiatry, as well as to do some more diagnostic studies and blood workup. So what was being done here at this point? What was reasonably prudent with what these physicians knew and what they knew it? What was happening was that they had a child being given levels of medication that they had never heard of before, that the literature did not support, that the literature didn't even mention. And so they put her in a safe environment, they attempted to get her stabilized, they called the correct consultations, and they tried to investigate what was going on. We will suggest to you, the evidence will suggest, and the experts will say, that that was a perfectly reasonable thing to do. There's no conspiracy here. It was an effort to safeguard this child and to see that she got appropriate therapy going forward, whatever that happened to be. Now, you'll hear that the admission diagnosis that was recognized at that time by Dr. Behar Cozy and ultimately by Dr. Tepa Sanchez was CRPS, chronic regional pain syndrome. There were other suspicions, and you'll hear about those too. But for now, I want you to focus on what CRPS allegedly has as its features, according to Dr. Kirkpatrick and what you've just heard from Mr. Anderson. It's lifelong. It's incurable. It can wax and wane. It can return at any time for any reason or no reason at all. It can cause a whole host of symptoms. And according to Dr. Kirkpatrick, who's the one who diagnosed it to begin with, it's incurable. It's always going to recur. It always requires ketamine. Now, if there's any suggestion made that Dr. Kirkpatrick wanted to try alternative therapy first and had some regard for what the previous doctors had done, we're going to invite you to listen to the evidence about that and to look at the evidence about that and see how much was done, how much was actually attempted. We believe the evidence is going to be that that wasn't something that was given a really fair, appropriate trial before ketamine was used. You're going to see, ultimately, Dr. Kirkpatrick, when this child was in the hospital in October and November of 2016, told Mrs. Kowalski that unless Maya Kowalski got more of his ketamine treatments, more of these high doses, she would die a slow and painful death. Well, thankfully, he was wrong, or has been wrong so far. And we think he will continue to be wrong. At this point, it's well to walk the clock back a little bit. I want to ask you to look at the evidence as you receive it on a comparative basis with these ideas in mind. You're going to hear, and you heard already, some recording from Dr. Kirkpatrick's first visit with Maya Kowalski and her family in September 23rd to be exact, of 2015. I want to focus for a minute on her condition at that time, what the evidence will show that. She was wheelchair bound. Her legs had atrophied. You saw the picture that Mr. Anderson showed you. Her legs and arms were hypersensitive to touch. She had limited use of her arms due to pain. You're going to see more of that. You're going to hear about pain in other parts of her body, alleged dystonia. She wasn't in school. She wasn't functional. She couldn't walk. She couldn't do her own ADLs. She had no normal function at that time. You're going to hear evidence that she came to that point from several admissions, primarily for asthma at all children's. But they also concerned a number of admissions at other institutions. Now, Mr. Anderson has mentioned to you what the evidence is going to show about Lurie Children's Hospital, where she was taken by Mr. and Mrs. Kowalski. Tampa General Hospital. Sarasota Memorial Hospital. She had been seen as an outpatient by the first physicians group here in Sarasota, the Sarasota Memorial Group. She had seen some physicians from Lee County. There was over 40 specialists that she had seen before she found her way to Dr. Kirkpatrick's office. And all of those specialists, many of those specialists that weren't concerned primarily with asthma, felt that in her presentation, some of them that were seeing her for asthma, felt that in her presentation there was some psychogenic component of some sort. And there were words like conversion disorder, psychological component. There was even one at that early point who was concerned about Munchausen by proxy. What I'm suggesting to you is all Children's didn't blaze this trail, we just walked it. We found it on our own, but we walked it. So did these other folks, all 40 of them. And actually the number's about 48. The point is that was not an unreasonable thing for Johns Hopkins to ultimately come around to believing and come around to suspecting, because many others had suspected the same thing. The recommendations for treatment of this disease, of the diseases that were suspected before Dr. Kirkpatrick, were physical therapy, psychological and cognitive behavioral therapy, sustained, long-term, intensive. That was back then. That's pretty much the therapy that Dr. Kirkpatrick rejected, because he began the course of ketamine. When Dr. Kirkpatrick saw her on September 23rd, you'll hear him say, I believe. He didn't care what the other doctors said. He didn't care what the records showed. He didn't review the records. He never contacted him. He never talked to him. There was no discussion in which he said, gee, I think it's this. I'm a specialist in this. You're a specialist in pediatrics. Let's reconcile our differences of opinion. Didn't do that. Instead, he diagnosed chronic regional pain syndrome. He's the first one to do it. And he began therapy, ketamine therapy. Now, you heard counsel talk about what the evidence is going to show Dr. Kirkpatrick did. Dr. Kirkpatrick will say in this courtroom or by deposition 1 that he began this child on a 4-day treatment of high-dose ketamine, what he considered to be high dose. You're going to hear, incidentally, that Dr. Hannah's high doses were multiple times what she was given by Dr. Kirkpatrick. He gave her 4 consecutive days of ketamine, and his records say that there was minimal effect. Minimal effect. He used opioids and narcotics to try to control her pain after those treatments. And we believe the evidence will show that as a result of those things, she wound up at All Children's Hospital with stomach pain and horrendous constipation. That was going to happen again and again following large doses of ketamine and other drugs. She was being haunted by these things. But in September and then in October, when Dr. Kirkpatrick treated her with high-dose ketamine, he prescribed more yet. And so she went to Mexico to see Dr. Cantu. I'm glad to hear Dr. Cantu is going to be here. Dr. Cantu, in his deposition, described to us what his regimen of ketamine consisted of down in Monterey. It's a treatment that is not approved in this country. He developed it from a trial in Germany. He'll tell you that. It contemplates giving the patient 7 to up to 9 milligrams per kilogram per hour for several days and keeping them in a coma with intubation for that period of time. He's going to tell you that it's a risky procedure. He's going to tell you that he tells his patients that there is a 50% risk of death from that procedure. Now he's going to say he's never lost anybody, but listen to the cross-examination of Dr. Cantu about the dangers of that treatment, the degree of ketamine that was used, how it was used, and what his expectations of success were. Because those expectations were not realized. And that's a key factor. Because what is going to happen here is that this child was given the same thing over and over and over and over again in increasing quantities, and it didn't work. And the first thing that didn't ultimately work was Dr. Cantu's treatment. She had to go back down to Mexico for a ketamine booster. Dr. Cantu will tell you that that's fairly usual, that happens, and that then he expects them to be pain-free for a number of weeks or months. Listen to what Dr. Cantu tells you about whether he knew anything about what happened after this. Because what happened after this was Maya Kowalski was taken back to this country. She was taken to see Dr. Hannah. Dr. Hannah embarked on a course of ketamine treatment beginning in January of 2016 and extending to the door of All Children on October 7th, 2016. 9 months of therapy, 55 treatments, an average of 1 a week or more. 55 treatments of ketamine multiple times in excess, not just of what the doses recommended by the manufacturers were, not just in excess of those, not just in excess of Johns Hopkins All Children's policy, multiple times in excess of what Dr. Kirkpatrick gave, multiple times in excess of what Dr. Cantu gave. You may even hear Dr. Cantu admit that he wouldn't give those doses in the circumstances that Dr. Hanna did. You may hear him say that he never gave them, period. But all those doses of ketamine and all that therapy and all those drugs over that 9 months, over that 13 months, we're going to ask you to look at the evidence and look at what the evidence shows about the result. The evidence shows that as of this October 7th, 2016, once again, Maya Kowalski is wheelchair bound, she's hypersensitive, she's unable to use her arms and legs, she's got chronic extreme complaints of pain, she's got leg atrophy, and said to have dystonia. Okay. And in that year, incidentally, she gained 4 pounds. Think about that. You're going to hear more about that. Because Dr. Hanna will tell you that he recognized that his patient was malnourished. Over that period of time, over a year, she gained 4 pounds. Now, she also, at All Children's, was on 21 different medications as of October 7th, 2016. 21 different medications. Let's compare for a moment what the evidence shows regarding Maya Kowalski's condition at the time of her first appointment with Dr. Kirkpatrick and the time she's admitted to All Children's a year later. You can see the slide. The evidence will show that she was in essentially the same condition with one addition. In addition to the problem she was having when she saw Dr. Kirkpatrick back in September 2015, in addition, she was malnourished. You'll also hear evidence that during that same period of time, there were 3 occasions, October 7th was the 4th, when she was in the emergency room complaining of extreme stomach pain following doses, high doses of ketamine and other drugs. We suggest to you the evidence will show that she was being harmed by these large doses of medication. The evidence will show you that the doctor's concern about how much she was being given and the frequency with which she was being given it was very well placed and is vindicated by what happened later. Let's take that comparison one step further. We believe the evidence is going to show you that between the time that Maya Kowalski was seen on October 7th in the ACH emergency room and the time she was discharged 3 months later, she had gained 4.5 pounds, which is more than she had gained in net weight gain in the last year before admission. She was still in a wheelchair, but she wasn't complaining of extreme pain constantly. She was comfortable. She was using her arms, and we believe she was improved. There will be evidence you hear from the witness stand about her condition at the time of discharge versus her condition at the time of admission. But perhaps more telling is the condition under which she was discharged. At that time, she went from 21 medications down to 3. And at that time, she began a course of physical therapy and counseling that, by the following school year, had her back in school. That was pretty much the regimen that was recommended for her at All Children's. That was pretty much the regimen that could have been given her earlier and sustained and perhaps saved her a lot of anguish and pain and perhaps this lawsuit. She got her physical therapy. She got counseling. Pain medications were withdrawn. You may very well hear that to this day she's on no pain medication. Now, you heard it suggested by counsel that she couldn't take ketamine. Indeed, when she was discharged, the court of this circuit, not this judge.
Objection.
The basis. What's the legal basis?
Motion eliminate.
I don't recall that one. Continue.
directed her discharge. She could not be discharged without an order of the court. And she was discharged with instructions as to what medication she could have at that time. She could not have ketamine. She could not have heavy analgesics without the court's intervention. That matter was dismissed several months later after she did well in her father's custody. And she's free to get whatever she wants today. But for the present, let me just mention this. I'll deal more with it. You're going to hear a lot more about it. Once the court entered an order following a report of child abuse that she was to be sheltered at All Children's under the custody of the Department of Children and Families, All Children's Hospital did not have the ability to discharge her without court approval, even if it wanted to. You're going to hear evidence. You're going to hear evidence from DCF personnel who will tell you we're the ones that set the visitation parameters. We're the ones that decreed who she could see, when she could see them, what she could have in her room, what she would have access to. The hospital, unfortunately, was put in the position of having to implement those orders. That's what we tried to do. But throughout this case, we're going to ask you to try to avoid conflating what was done by the court or ordered by the court with what was done by the hospital. Because the hospital's not the court. The hospital's not DCF. The hospital has to follow that. And the hospital doesn't institute that. The court and DCF do. Now, I digressed a little bit there, but I want you to pay attention, I'm sure you will, to what the evidence will show regarding Maya Kowalski's condition today. If she's not the head of her class at Venice High School, she's real close. She served in her student government. She works out. She's on track to get a high school diploma and an AA degree on time. She's dating. She's functional. She walks unassisted. She's not taking pain medication. To some appearance, she's doing very well, and we hope it stays that way. Now let's walk back the clock once again to October 7th, 2017. At that time, we described somewhat what happened in the emergency room. You're going to hear more about that from nurse witnesses. Maya Kowalski was admitted to the PICU. We talked about that. Dr. Beatrice Tepa-Sanchez was the one on duty that night. You'll see what her credentials were. She'll tell you what her credentials are and her board certification in pediatrics and intensive medicine. She will tell you that what she did was attempt to understand what was going on with this child. And you'll see her, and you'll hear her walk through her admission history and physical, and the research that she did into the records that were available to her at All Children's of previous encounters. You'll see her discharge summary, and you'll see the care that she took to track down what this patient's history was. And you'll see that when she did that, and she was able to get the child admitted and sedated and started stabilizing, that she did call appropriate consultations. She did get pain management and anesthesiology involved. She did call psychiatry. And because of her concern, you'll hear that she also called a pediatric child abuse expert, Dr. Sally Smith. You'll hear Dr. Smith is the head, the medical director of the Child Protection Team, the CPT, for DCF, the Division of Family Services, or excuse me, the Department of Children and Families. I just gave away my age, by the way. They used to call it the 70s. But in any event, you'll hear she contacted Dr. Smith to say, basically, I'm not sure what's going on here. Can you check this out? And you'll hear that Dr. Smith did. You'll hear that Dr. Smith was not an employee of All Children's Hospital, that she was not part of the treatment team, but she was there as a resource. And you'll see over time, and we'll talk about this again in a minute, the investigation that she conducted in connection with her duties with DCF and the Child Protection Team. She was not an employee of All Children's and never held herself out as such. And you may hear from Mr. and Mrs. Kowalski themselves that they knew that from day one. Now, I mentioned that Dr. Tepa-Sanchez got her colleagues involved. One of those colleagues you'll hear from is Dr. Richard Elliott. Dr. Elliott is a board-certified anesthesiology in pediatrics. He will be here and testify about what he found, what his interactions with Mrs. Kowalski were, and how he believed this child needed to be weaned off of high-dose medication and weaned off of the regimen that she had been on. You'll also hear from Dr. Jenny Dolan. She's in the same discipline. She too had interactions. And you'll hear from both those doctors that during the time they were caring for this patient, they were having a problem with what Mrs. Kowalski wanted. Mrs. Kowalski wanted an intrathecal pain pump placed in her daughter's spine to deliver a medication called clonidine, powerful drug, into her spinal canal. She was told that was a bad idea by the doctors at All Children's. She was told the same thing by doctors at Nemours. Indeed, you're going to hear Dr. Kirkpatrick tell her that's a bad idea. She was insistent upon asking for that over and over. She was talking about taking her daughter back to Mexico and Italy for more high-dose ketamine that she had just come off of, and that the doctors at All Children's felt weren't working, and frankly, we would suggest to you the evidence suggests weren't working. The plan of care that the doctors wanted to pursue was consultation, weaning of the medications, appropriate care, and ultimately transfer. Now I'm going to go past the slide on Dr. Smith here and go fast forward here because I want to talk about several specific allegations that have to do with the sequence of events from this point forward in the case and what the evidence is going to show you about that sequence of events. This child was admitted with a consent form agreeing to treatment signed off by Mr. Kowalski on October 7th of 2016. By that Sunday, the family, particularly Mrs. Kowalski, wanted to leave. They were being dissuaded from that. They'll tell you that on the morning of October 10th or 11th, that they were told they couldn't leave. I'm going to invite you to listen to what the evidence will show about that encounter. Because we believe the evidence will show, and you hear Mr. Kowalski say that no one ever told him he could not leave All Children's Hospital. We believe the evidence will also show that at that time, with the threats being made by the mother to find more high-dose, dangerous ketamine, that it was reasonable and warranted for the doctors to decline that if they had chosen to do so. We don't believe they did. We think that the evidence is more persuasive and shows you that there was a convocation of folks on the morning of October 10th or 11th at which there was discussion of the plan, there was a discussion of the weaning, there was a discussion of stabilization, the plan being, let's get her weaned off this medication safely, and then let's transfer her to an institution where more intensive physical therapy, more intensive behavioral therapy, and more intensive occupational therapy is available. The evidence will show you that All Children's Hospital was not trying to imprison this young lady. We were trying to get her stabilized and transferred to somewhere where she could get the help that she needed. And you're going to see that that somewhere was identified by Dr. Michelle Smith and others as Nemours Children's Hospital. A brief look at Dr. Smith's qualifications. You're going to hear from her from the witness stand. Dr. Smith is presently our chief of staff. She's also a board-certified pediatrician and intensivist. She came into this case on October 9th, and she virtually from the outset began discussing with Mrs. Kowalski transfer of the patient. Now, there's her plan of care. That's what she wanted to pursue. And she tried to get it done with a transfer from PICU to Nemours. She felt at the time that if she transferred the child to Nemours, the intensive pain management program could begin while the child was still an inpatient. Nemours declined the transfer. She didn't stop, though. So I'm going to skip past this slide because we pretty much covered it. She didn't stop. After that discussion at which the family agreed to stay, and you're going to see multiple sources of documentation of that, after that discussion, she took it upon herself to call Nemours again. And she called a doctor named Lisgelia Santana Rojas. You're going to hear that Dr. Santana Rojas, and you're going to hear from her, we believe, by Zoom. You're going to hear Dr. Santana Rojas verify what she was told, or what she told Mrs. Kowalski, and what Dr. Smith will say she told Mrs. Kowalski. And that's basically this. She said that Nemours wouldn't take a transfer for inpatient, but that Dr. Santana Rojas operated an outpatient pain management clinic, specializing in pediatrics because that's all Nemours does, just like all children. All we treat is pediatrics, all they treat is pediatrics. In their pain management program, they treat CRPS. You'll hear Dr. Santana Rojas describe that she told Mrs. Kowalski that. You'll hear her say that she was asked by Mrs. Kowalski, if I go over there, if I come to your program, will you put in an intrathecal pain pump? And Dr. Santana Rojas said, no, we won't do that. That's not part of our program. That's dangerous. It's against your daughter's interest. But what we will do, without ketamine, without analgesic, what we will do is give her intensive physical, occupational, and behavioral therapy, and I'm going to replicate with her the program I trained in at Boston Children's Hospital, Harvard Medical School. I've replicated that program here, and we're getting very good results. If you bring your daughter over here as an outpatient, we'll put her in our program. You hear Dr. Smith pretty much tell you the same thing. I'm not sure what Dr. Santana Rojas is going to say about this, but I know what Dr. Smith's going to say. And it's this. Dr. Smith left the hospital that day thinking she had a deal. She thought, okay, we're going to get this child weaned and stable, and then we're going to transfer her as an outpatient in her family's custody to Nemours Pain Management. Now, as you hear the evidence come in, you are going to see that at this point, on October 11th, 2016, there had been a report accepted to DCF. There had been an investigation started, but nothing really had taken place. There had not been a dependency petition filed. There had been no court order. The court hadn't denied the Kowalski's access to their daughters. They hadn't done anything. At this point, on October 11th, All Children's Hospital and its staff were attempting to facilitate Mr. and Mrs. Kowalski taking their daughter out of All Children's Hospital in their custody and taking her as an outpatient for treatment at Nemours. We suggest to you that if that had happened, we would not be together today. We're going to suggest to you that the evidence will show that if that had happened, it's reasonable to think that none of this would have occurred. We believe that had that occurred, this entire matter could have been sidetracked and never brought us together. But that's not what happened. Because the next morning, when Dr. Smith arrived back at the hospital, she found that Mrs. Kowalski wanted to take Maya Kowalski to Dr. Hanna for more ketamine, that she wanted to seek an intrathecal pain catheter elsewhere, that she wanted to obtain more ketamine elsewhere, and that there was still discussion of Mexico or Italy. Shortly after that, there was a shelter order in. At that point, the circumstances under which Maya was a patient at All Children's were not dictated by the hospital, they were dictated by the court and DCF. Now, the situation proceeded with the weaning completed at All Children's. All Children's, the evidence will show, attempted to get this child the physical therapy on an inpatient basis that it could provide. We didn't think it was enough, but we did what we could. She got some behavioral therapy, although not the kind that she needed. We didn't have it available. That's why we wanted to transfer her. But you'll see as you go forward and you hear witness after witness and you look in the hospital chart, you're going to see that over and over and over again, we weren't warehousing this child voluntarily. You'll see it noted over and over. Medically cleared for discharge, awaiting court disposition. At the close of all the evidence, we'll tote up for you the number of times that appears in the record. But we're going to suggest to you the evidence is going to be conclusive that there was never any false imprisonment of this child at All Children's Hospital. Now, I want to talk, before I get into disease versus syndrome and problems with diagnosis, I want to talk about a couple other things. One is the matter of a battery and surveillance. We believe the evidence is going to show you that whenever there was a touching of Maya Kowalski, it was done for therapeutic or clinical reasons or to comfort a child. There was never any intent to do her any harm. There was never any intent to be offensive or harmful. And we believe that at the end of all the evidence, you're going to find that there was never any point at which a reasonable person would have taken offense at how she was touched and how her care was managed in that regard. We need to talk a minute about the problems with diagnosis here. You're going to hear a lot about CRPS, conversion disorder, and a number of other things. CRPS and conversion disorder and these mental diagnoses have a couple of things that are significant about them. One is that they aren't diseases in the sense that doctors use that term concretely. A disease is something that you can see and you can diagnose, and there isn't any question about it. Appendicitis, most forms of cancer. There's the lab test that proves it or disproves it. If you have HIV, there's a lab test for it. If you have appendicitis, there's an imaging study that shows a hot appendix. Objective. Syndromes aren't like that. In a syndrome, you piece together a constellation of symptoms and a constellation of findings, and it's much more subjective. And that's why we have things like the Budapest criteria that counsel talked about, and you're going to hear a lot about that going forward. In this particular case, you're going to hear that there was a good deal of controversy about what this diagnosis was. When this patient came into All Children's, we did in fact admit her with a diagnosis of CRPS. And we continued to bill for that and to treat that, and we tried to transfer her with that diagnosis. But as time went on, for the same reason that CRPS was not suspected at Tampa General or at Lurie's or elsewhere, we questioned the diagnosis. And while the diagnosis was carried forward as a rule-out, it was not the discharge diagnosis, although we noted in the discharge summary that it was never ruled out. Now, you're going to hear much about CRPS, but I'm going to skip past this slide because we kind of covered this. You are going to hear a lot about CRPS's rarity, and you're going to hear a lot of reasons given why we didn't believe this is CRPS. One reason was that it was presenting as a general pain syndrome involving the entire body. What's the name of the syndrome? Chronic regional pain syndrome. Doesn't usually present as whole body. You're going to hear that's vanishingly rare, if not almost unheard of. You're also going to hear that there are various presentation factors about this disease that were never really observed on a consistent basis. Like decrease of hair loss, nail changes, skin asymmetric tissue changes in the skin. A lot of these observations about CRPS just weren't consistently present. There were, however, reasons to suspect conversion disorder. Now we've arrived at psychiatric or psychological issues. There's a lot of misconceptions about psychology and psychiatry and mental illness. And people act like saying it's conversion disorder or it's all in your head is some kind of epitaph. It's an insult. And that's not the case. When these doctors are writing down conversion disorder, they weren't trying to insult somebody. They were trying to attach a suspicion and a diagnosis to get a patient the help they needed. No one's telling this patient she doesn't have pain. What they're saying is, what their question is, what's causing it? And what you do about it. And that's the central issue here in many respects, because this entire case revolves around not so much what the diagnosis is, but what the clinical treatment is. And I've got a slide here in a minute that will show you this, but I'll probably skip when we get to it because now I'm taking it out of order, because as usual in an opening statement, I'm way off the reservation from what I'm supposed to be doing in order. But since it's appropriate, I'll say it here. When you look and when you hear what the evidence is about the reasonable standard of care treatment for CRPS, for conversion disorder, for a pain syndrome manifesting as Munchausen by proxy, for factitious disorder manifesting as a pain syndrome, when you hear what the treatment is, the clinical treatment is for all those things, same thing. Maybe the mix differs, but it's basically physical therapy, occupational therapy, and psychological or cognitive behavioral therapy. Those are the treatments. And you're going to hear from experts who treat this disease day in, day out, and these diseases, I should say, all of them, day in, day out, and they do it without putting the patient in a coma, without giving the patient 15, 20 times the recommended dose of ketamine over months and months and months. They do it by therapy, and the results they get are stellar. And you'll hear that from them. You'll also hear that for that same set of reasons, this business about billing just isn't supported by the evidence. You're going to see the billing records. You're going to see the billing sheets. You're going to see that CRPS was an item. It was one of a number of items that was being billed for. You're going to hear that there was no change in the medical reimbursement for the billing as a result of where, in what place, whether it's 1 or 12, and that's literally how many diagnoses there were that points in this, whether it was the first diagnosis or the 6th or the 8th or the 10th, you're going to hear that the billing reimbursement never changed. And the reason for that was that while you needed a diagnosis to put on that code, what was really being billed for was the services rendered. And you'll see the billing sheets and the services that are laid out item by item, and you'll see that those didn't change either. You'll also hear that none of this cost Mr. Kowalski a dime. And you'll also hear that the insurer who was billed for the services rendered by All Children's Hospital for 3 months of inpatient therapy, the insurer never complained. Didn't say a word. Approved the care, approved the billing, no problem. Now, you're going to hear a lot about Munchausen by proxy, and I'm going to kind of fast forward through this for one reason, that we're running a little bit low on time, but the other reason is that it's a very technical thing, and it doesn't merit near the attention that it's gotten because it's been a flashpoint throughout this. There was a suspicion of Munchausen by proxy. It wasn't just All Children's suspicion. There was a concern that part of this child's condition was being fostered or encouraged by the mother. There was a concern that the mother was seeking out care that was too aggressive, that was dangerous, and would persist in doing so if she were permitted to do so. That's what got this ball rolling. And I told you a few minutes ago what the evidence will show about the attempt to transfer for outpatient care, why it failed, and why, as a result of that, these investigations rolled forward. This is a slide I told you I'm going to skip because this talks about what the therapy is and how it is all of them. We talked about billing fraud, so I'm going to skip over this slide as well. Let me talk about photographs for a minute. You've heard about the photos that were taken. These photos were taken for clinical reasons. We believe the evidence will show you that they were taken pursuant to the consent that Mr. Kowalski signed when he was admitted, and which he will, I believe, admit to you he never rescinded. The purpose of the photos was to document the condition of the child. If there were skin lesions, even if they were not being documented in the nursing notes, they needed to be documented, they needed to be observed if they got worse. If there were new ones developing, we need to know that too. But the point is that they were being taken to assist in diagnosis and follow the child's condition. You heard about Surveillance, the movie, surveillance video. You're going to hear that wasn't a new idea either. That also happened at Tampa General. Why was it done? Because medical professionals wanted to know what the child's capabilities were. Now, that video is going to tell you you're going to see, we're not going to ask you to watch 42 hours of video. But you're going to see grabs from that video that show several things from our standpoint. You're going to hear some of the plaintiff links. From our standpoint, you're going to see in that video that Maya Kowalski, who's saying her legs are hypersensitive and can't be touched, saying she can't move her legs, is moving her legs in bed, moving her legs into a position that we used to call Indian style, and now we call crisscross applesauce. She was able to assume that position and hold that position voluntarily without a problem. You're also going to see and get some idea of the fact that she was not in that room for 42 hours. you'll see that she's in and out. She went to therapy, she went to other places. And you'll see the nurses coming and going and assisting her when indicated to the commode. The commode wasn't placed out of her reach for any kind of malicious purpose. It was placed in the position that it was because she had nursing staff available to help her, as you'll see they did, and because if you put it too close or in too close a position to the bedside, it would obstruct the nurse's ability to get to the bed. It was strictly a matter of happenstance. It was not a matter of intent. And that brings me to another point, and it's on this slide. You're not going to hear any evidence that the 50-some-odd medical doctors and professionals who took care of Maya Kowalski over 3 months somehow banded together in some sort of cabal and hatched a plot or a conspiracy to do harm. You're just not going to hear that. You're instead going to hear from a constellation of dedicated pediatricians and dedicated specialists who were genuinely trying to do the right thing to this patient. They may have differed in some opinions with the family, but their uppermost objective was to keep this child safe and to get this child the therapy and the treatment that she needed. Now, why was the diagnosis an issue if the treatment was the same? That's a reasonable question. Let me suggest to you that the evidence is, and will be, that the importance of the diagnosis is the result of the fact that that CRPS diagnosis was being used to justify dangerous care, dangerous levels of ketamine and other drugs that aren't even recognized in the literature. Those doctors weren't going to come.
Okay, the video just cut out. Give me a second. See if it'll reset here. Internet connection's good. Just remind everybody, we knew this was going to be a tough case. It's going to be a very difficult case. So just hang in there.
Going to take the patient to those
Let's
doctors.
try to keep our strong feelings out of chat.
And so it was important to get the diagnosis straight and the treatment straight so that the right mix of therapy could be formulated and the best job could be done to get Maya Kowalski into a position of being comfortable, functional, and lead a happy and healthy life. That's what we were attempting to do. There's never an intent to do anything but that. Over the next few weeks, we think you're going to hear a number of experts in the courtroom. We'll be bringing in experts from California and elsewhere. They're going to talk to you about whether or not the overarching allegation against All Children's and its physicians, including even Sally Smith, that they were negligent in Maya Kowalski's care and that their negligence somehow caused injury. We're going to suggest to you that, first of all, there was no ultimate injury caused, given the condition that she was given to us in. But more importantly, there was no deviation from the standard of care. You're going to hear from different doctors in different specialties that the care that was taken in diagnosing and treating Maya Kowalski, you're going to hear about teams of consultants, you're going to hear about meticulous investigations. You can see that Sally Smith formulated a 45-page single-space report of her review of literally thousands of medical records to come up with her diagnosis. You're going to see a lot of effort and care and expertise went in to the effort made to treat this child at Johns Hopkins All Children's Hospital. We believe that the evidence will be unequivocal that that degree of effort, insight, investigation, and monitoring and care comported in every respect with what is reasonable and what is recognized as being reasonable and appropriate by other similar physicians. And we don't believe you're going to hear any credible evidence otherwise. You heard the judge give you a definition of medical negligence. I just kind of paraphrased it. But the point I'm making to you is that the evidence will ultimately show that these doctors and these nurses and this hospital staff acted reasonably and prudently to treat a difficult and challenging case they were presented with, and they did it consistently over 3 months. They don't have to be right under the law. All they have to be is reasonable. And we will suggest to you that the evidence will show that, first, they probably were right. But even if they weren't, they were more than reasonable. At the end of all this, at the end of all the evidence, I'll have another chance to visit with you, or my colleague, Mr. Shapiro, will. You're going to hear a lot between now and then. And again, I appreciate very much your attentiveness and your diligence, as does my client and people at All Children's Hospital. I thank you for your attention and look forward to working with you in the next few weeks. And you'll be pleased to know I skipped at least 3 slides. Thank you.
May I see one of the lawyers from each side, please?
Okay, so I think this concludes their. Switch over to here for a second. I think this concludes their what happened yesterday. I know they just broke for lunch today, so we're catching up. Oh nope, there's some more stuff today. So let's see. Is it playing? There we go. So we do have a little bit more. Are we still on high speed? I think 1.25 speed.
Members of the jury, we're going to be letting you go here in a few moments. First thing, and Debbie Coley, I told you I was going to give you all a telephone number, so Debbie Coley will give that out to you. This is so you can give to a spouse or anyone that might need to get a hold of you in an emergency. So he'll give that to
contact
you
the jury
as you go.
Wow.
Now, was there anyone, I know I asked at the beginning of the morning, was there anyone that had an update relative to any sort of issue? Is there a note that you can send to me, or everything's fine? Glad to hear that. Okay. Well, I appreciate you sharing that with us. Okay. Tomorrow we're going to start evidence. I'm going to ask the deputy to tell you exactly, where to go, but at the same time, arrival that you did today, you need tomorrow, because my goal is to bring in exactly at 9 o'clock and we'll start evidence. Remember, do not discuss this case amongst yourselves, do not do any investigation, and receive no information. And with that, if you could follow the deputy, who will let you get out of here.
All right, thank you.
Leave your notes. Just put it in the Redwell, and we will take custody of them tonight. Yeah, leave them on the chairs.
Okay, so we have a couple things to talk about.
There's a number on there.
Monday, they will not be having court. So
this isn't our first rodeo.
I think we're going to save the video that's happening today to watch on Monday, because they won't have court Monday, so we'll be caught up then. Tuesday, there's going to be trial. Wednesday's no jury, possible hearings with the attorneys. Thursday's trial. Friday's trial next week.
The jury is out of our presence.
We're going to finish the operations today, and then I think we're going to break until Monday to catch up on what happened today.
When we were talking, there was some discussion about the possibility that you all wanted to spend some time with me this afternoon, but it was unclear. So do you all need to have hearing time this afternoon, or do you want time to start working on your presentations and questionings for tomorrow?
Both. But we're not going to be able to do that. Judge, we have a lot of work to do, but we would like to know if there's a way to time it so that we can send over the exhibits we intend to put in to both the court and opposing counsel within the next few hours,
And then if there's going to be some objection or something, if there's any possible way of either later on today or tomorrow, I'm happy to come in and bring witness after witness and spend the time on the on foundation predicate and so forth. But it's a colossal waste of time for things like photographs and most of the other records.
I'm not sure I understand what you're asking.
I'm asking for the court's advice and direction in terms of getting in in a procedure for getting our exhibits in tomorrow in the most efficient way. I would like to provide defense counsel with a list of them pronto and require them to get back with any specific objections or stipulations so that I know by the end of the day how to time my case in terms of asking for a foundation predicate introduction questions to my witnesses.
So you mean like which specific exhibit you're going to tell them? Because my understanding is we've got 80-something binders of exhibits here that you all have submitted. Wow. And so some are binders agreed to and others are not.
Correct.
So
the not agreed to ones, I think what the court will find is the vast majority of the exhibits are medical records. But when it came to most of our case, the photographs, videotapes, the recordings, various notes, letters, anything else other than medical records, there are objections. Except I don't know what the basis is for those objections, and we've never had a chance to talk about it. We had representations that we would get those back. We still don't know what their position is on it. We have trimmed down 3 times our exhibit list at the court's suggestion, at counsel's suggestion. We have provided responses already to propose to what we think may be an objection.
What time are you suggesting that you're going to actually let the defense know what exhibits you intend to use tomorrow?
3:30, 4. 4 o'clock would be good, and if we would know back by 5. I mean, Judge, these things have been around for years and years.
Well, Mr. Anderson, it's the same issue we've been having over and over and over again. Until you tell them specifically what you're doing, you can't ask them to say, there's 4,000 exhibits, tell us which ones you have an objection to. You can't do that. So yep. I'm not hearing Mr. Whitney say 4 o'clock, and then you want them to return in an hour. So, I mean, it would seem to me like you really should be telling them, just like with the witnesses, by lunchtime. And maybe you can't do it today, but really in the future, perhaps what we need to do is by lunchtime, coming back from lunch, letting them, the other side, know, because that's what we're doing with witnesses. And then, so are you able to do it before 4 o'clock today?
Yes, and I want to emphasize to the court, we're not talking about a vast amount. I would say 30, we don't know yet, but I was estimating 30 to 35, and these are photographs and things that are going in through the witnesses tomorrow.
Well, again, to the extent that you're going to be using them, the earlier you can tell the other side, the earlier you're going to get a response. I mean, it's just as simple as that.
And is it possible, Judge, that I know everybody likes argument on these things, and that is required if asked, but is there any way that if we can receive back concise objections, that the court can be informed and we can provide the court with either the base number or email over to you the actual exhibits?
As they're arguing this back and forth, just remind people, this is a fun place to watch. We're all friends here. I'd ask you to please be kind in chat. We took this one. I debated not taking this case because there are some very strong feelings, and honestly it's difficult for chat to handle this. It's difficult for our community because people have strong feelings on both sides. I'd ask that you be mindful of those. We would like to continue following this case, but if chat devolves into just the same thing you find over on LNC or somewhere else, that's no benefit to anybody. So let's please just be kind and respectful to everyone. Appreciate that.
Beyond that, they're photographs instead of, all he did was make them composite exhibit, but there's hundreds of them. So, and we most likely will be objecting to the audio recordings. We have told them that over and over again, and we have indicated on their exhibit list what our objections are. Hearsay, 403. I mean, I don't know what they mean by the specific objections. These are our objections. So we're happy to look at the 30 exhibits, if there's really 30 and not 330 exhibits they send over today, and again advise them one way or the other if we will agree or not agree. Happy to do that. If they want to send us 30 exhibits and say these are the ones we want to use tomorrow, we will review them and give them our response.
Well,
okay, they're still fighting over the evidence. I will say, what I forgot to include in that little comment is I appreciate the different opinions that are here. I love it when somebody can come and literally share something that I didn't know, and educate me and possibly change my mind on things. We just have to be very cautious how we're doing that, because just be mindful there are a lot of people with some very, very strongly held beliefs that are based on personal experience for them, and their scenario, what they went through is very real, and so just when you're presenting that, present it in a sharing way, an informative way. We don't need everyone to have the last word, and I'd ask that you give everyone a little bit of grace and space, and we can learn together and be better off by having everybody here. So thank you very much.
Because we didn't have our ducks in a row. So if we need to start earlier than 8:30, I'd rather start earlier than 8:30 so that the jury does not get inconvenienced.
Can we remain in touch with the court? We don't want to underestimate. Can we remain in touch with the court? And can we, by email, I know your rule, can we keep the court apprised by each side sending in for us the exhibits, them the objections, and our estimate of the time?
He does not want to be in the middle of this.
Judge, if we don't get them till 4, I don't know.
Well, I mean, I thought y'all were going to get the script to me around 5 o'clock, and it was 9:15 last night. And I understand. I was a trial attorney too. I understand you have a tremendous amount of things going on. It's just, I'm concerned that you're not going to get things in time for us to have a hearing this afternoon. So I think it's going to have to be tomorrow morning. I am fine reviewing things ahead of time, like I did with the things that were tendered last night.
How many lawyers will be standing by the end of this?
To the extent that I need to respond, like I did last night, I will respond, and we'll use that email address that we used last night. But I do not want this to become a daily habit where I'm having to email correspondence with you all at 10 o'clock at night. I just don't think
does
that's
not want that at all.
Good for anyone.
Right. Ellie, thank you so much for gifting 5 memberships. That is super generous.
I avoid doing it
thank you.
Like that. So, what time do you realistically think, Mr. Whitney, that you can get them? since I know Mr. Anderson's writing checks off of your back, so.
5 p.m. is fine, and I understand an hour for them to respond is not reasonable, but if we could get a response, that's about 4 hours for us. If they could have 4 hours and get us responses by 9 o'clock, and then we can have some hearing time in the morning.
Is there any way I can get you to give to them by like 3? Ooh. Which is 2 hours, 15 minutes from now.
Can we do it in a couple tranches? We'll give them as many as possible by 3, and then follow up, and if a half hour later we've got a few more.
How do you want them to scroll this?
Judge, I don't know that it matters. I think ultimately we're going to need some hearing time in the morning. I think that I don't think we should bother the court with it overnight. I think we'll exchange what we can exchange. We'll come in the morning. You'll know which ones we object to, and we have a 30-minute hearing on it.
Well, so you're okay with them sending them in waves?
Yes, sir.
Okay, so send them in waves to the extent that you can. What time?
There will be waves.
Mr. Altenburn,
he's
look like you need to say something.
There are a couple. Well, first of all, I'm happy to work on jury instructions with the convenience of the court. A lot of that looks like it can wait.
I'm thinking Wednesday morning is probably
a good time.
Wow,
or sometime on Wednesday.
Already talking jury
the
instructions.
Openings caused me to have a couple concerns, and I would be happy to file a brief memo so that we could have that early on. But the two concerns are, first, that they began their opening and they've talked a lot about the period in 2015 before October 7th, and discussions that suggest to me that they're thinking of proving a malpractice for failure to diagnose them. And that's not pled. It would have been outside the statute of limitations if it had been filed. And so I just don't want to start having a case going forward on evidence of something that isn't that is not really an issue within the pleadings. And the second thing is that it appears from their strategy of not discussing the DCF proceeding hardly at all that it's no longer that we cause DCF to have bad visiting policies, and I guess the orders become sort of an affirmative defense now from this, which is fine with me if we have it as an affirmative defense. I just need to kind of understand how we're going to be going forward on the Chapter 39 issues that seemed to take a different twist this morning than I was envisioning.
Given Mr. Elligott's motion about 10 days ago, I kind of assumed that was their change.
I wasn't certain whether that was their change or how they were going forward, but now it's clear.
Okay, so how much time tomorrow do we need?
Last just seemed out of place.
Do I start court at 8:30? Do I start at 8:15? Do I start at
8:15 probably would be best, and then because the jury's with the goal of getting the jury in at 9.
I want the jury walking in this door at 9 a.m.
I'd say 8:15.
That's fine too.
Let's go over the schedule again. Friday is a day that we're having witnesses. Monday is a religious holiday, so the court will be closed on Monday. We will have evidence on Tuesday. We might have legal arguments on Wednesday morning, but no jury on Wednesday. And we will have a jury with us on Thursday and Friday. So next week, we'll have a jury with us Tuesday, Thursday, and Friday.
It gives an idea of the schedule coming up, so we
One
might
other
have some other things we
note,
can fit in there.
as far as the Zoom and the rule of sequestration, technically I don't think either side has actually invoked it, but I assume one side is.
May I make a motion?
You're invoking it?
Yes, and I have a couple of corollaries to that when the court's ready.
Okay, let me finish. The way I'm running Zoom for the security settings, I don't have any control over who comes in. So if you all are going to invoke the rule of sequestration, you have to, and I'm going to specifically direct each side to tell your witnesses that they are prohibited from monitoring the trial. So are we invoking the rule of sequestration?
Plaintiffs move to invoke the rule.
Okay.
Two corollaries to it. One well known, the other one I think the case law supports. Kyle Kowalski as a beneficiary traditionally are treated as parties for the purposes of the rule. So I'm hoping there won't be any problem with him staying in.
We didn't invoke the rule, Judge.
I'm sorry?
We didn't invoke the rule.
Well, if the rule's been invoked, then Kyle Kowalski's not a party, and so would be part and covered by the rule of sequestration.
Kyle gets
unless
kicked
the other
out.
side agrees.
So they are invoking the rule to exclude one of the beneficiaries, a 15-year-old child. Am I clear on that, counsel?
Yes.
Wow.
All right, and the second then is judge as to experts. Traditionally, experts are exempted from the rule to the extent that they are necessary to take in testimony or evidence upon which they will comment later in the trial.
And when you say experts, are we talking about those people that were specifically identified as experts on the witness list as opposed to a more generic description of experts?
This guy gives me the I feel like Kevin from The
Our
Office.
idea were true retained experts, although based on the court's rulings, there's a lot of what were traditionally known as non-retained experts that have been through the litigation treated as experts.
Which is why I'm asking the question.
And so, everyone is non-retained. Right. Anyone who's we're invoking the rule as to anyone who is not a non-retained. If you're a retained expert, yes. If you're non-retained, no.
What would that do to the doctors? From
Mr. Whitney.
We'd like both retained and non-retained experts to be allowed to observe, and both sides have retained, both sides have non-retained experts on those lists that you mentioned.
When you say a non-retained expert,
Non-paid.
Are you talking about somebody that you did not designate on your witness list as an expert?
No, we're talking about the treating physicians that we had the hearing over where there was a determination of whether they were one or the other.
The expert lists that were filed on both sides named both retained and non-retained experts. So I'm talking about both categories, Your Honor.
I don't think his lawyers are on the same page.
It'd be nice to know who we're talking about here.
I'm trying to figure that out.
The names, how about some names?
My only comment at this point, where we're kind of at the blue smoke and mirror stage, is that if it's good for the goose, it's good for the gander. And we're going to. The reason I say that is we're going to have doctors who want to watch. We're also going to have doctors who are in and out as corporate representatives. So and many of these same doctors will be asked expert opinions on the stand, even though they were arrived in the course and scope of their treatment, and even though they're not experts.
Well, I would suggest that both sides discuss with each other and see if you can come to an agreement, because ultimately I'm either going to do one of two things if you can. Either it's going to be no one is allowed, period, the end, because it's going to be easier to enforce, or it's going to be only those that were specifically identified as an expert on the actual most recent expert list. It's going to be one of those two. Probably the former, but I could probably be talking to the latter, unless you all can agree otherwise. And I think it's, instead of a broad category, I think you need to sharpen the pencil and say this person, this person, this person, and this person.
So, Judge, for the record, we are objecting to rotating corporate representatives.
Yes.
They should designate one representative. They've invoked the rule. They will not let Kyle Kowalski in.
They need to hold tight to that.
We believe that under the rule, they can substitute a corporate representative, but not on a rotating basis, and it has to be after they have testified. So that they don't use that as a means of just bringing people in to
allow
listen to
Kyle
the testimony.
And I will tell you, there is some that argument's resonating with me. So perhaps what you all can do is discuss that as well, and see if there's an accommodation that can be made on either side relative to
the judge is saying
your corporate reps and Kyle Kowalski.
There it is. He's like, hey, you guys both want something
What's
that's
that?
not normal.
That's not trade you, Kyle.
Let's see.
They'll trade you, Kyle.
Well,
we need to talk about it, Judge.
about
I mean, I'm not. I've done this both ways, and I prefer to work something out.
And I hope so, because I feel like I've already spent more time on the rule of sequestration in this case in the last 5-10 minutes than I have in any other case ever. So
wow.
let's see if you can work it out amongst yourselves.
He said, I'll trade you, Kyle.
I'm waiting for right now, Your Honor.
A little flippant.
Why should that issue be needed?
I am hopeful we're going to have a very smooth professional trial. That's what I expect of both sides, and nothing less is going to be tolerated. 8:15 tomorrow morning, we will start with legal arguments with the goal of having the jury walk in at 9 a.m. The court deputies will open the courtroom at 8 a.m. tomorrow morning, and I'll try to have the Zoom open and as well at that time, and I promise to try to remember to turn on the microphone this time. Okay.
All right.
Have a good day, everybody. We'll be in recess.
Okay, so let me spell this out just a little bit. The sequestration rule that has been invoked, the judge doesn't just invoke that on his own. He waits for somebody to ask for it. It can be either prosecution or defense, but once that's asked for, then nobody can, anyone who's on the witness list can't witness. Hang on, Ember. Hang on 1 second. I need to find my plug so I can hear you. Hang on. Okay, so anybody who's on the witness list cannot watch any other testimony because they're being sequestered. They're not supposed to hear anything that's happening elsewhere in the trial. Now, the exception is the expert witnesses, and typically there's a rule for family members or victims. In this case, Kyle is listed as a beneficiary. Kyle is the sister of Maya. So they're saying we want an exception we want the rule invoked, but we want an exception for Kyle. The hospital comes back and says, no exception. We're not going to let him be there. Kick him out. You want sequestration? He can't be here. Which, having a 15-year-old or a young kid on there the whole time, the jury gets to look at him in the eyes and say, are we voting against him? Are we hurting him? Or is it harming him? It helps to have him there. But at the same time, the hospital side on the defense is asking and saying, we want to have doctors here, and every day we'll have a different doctor, and it will just rotate, and we'll just show you how many doctors are on our side on this. And so they're both asking for something that will make them look better in the eyes of the jury, that are in violation of the sequestration rule. So now they're going to trade. They're going to swap horses, so to speak. And I think they're going to give in. You're going to see rotating doctors, and you'll have Kyle there. That's going to be their agreement. Otherwise, you'll have neither. Amber's on the phone with us. Amber, are you feeling any better today?
Kinda.
Kinda.
Yes,
You sound miserable. You sound miserable.
I sound very different than you're used to hearing me. Hi, everybody. I know everybody's been worried about me. I've got lots of DMs. Thank you for checking on me. My house has just been recycling the crud for the last few weeks. So I wanted to call in and give a little context here. And I'm sorry, I just kind of threw this case at y'all. I promise this weekend I will get you a glossary of terms and definitions of what things are and what they mean. Mm-hmm. And pronunciation guides.
Make sure you write the pronunciation guides in crayon, because that's what I require.
I got it. I got you.
Make it easy on me.
Anything but yellow, right?
Yeah. Yep. That works.
Yeah.
Thank you. Thank you. By the way, you also sent me the guideline, the schedule, which the judge went over briefly as well for next week. So Monday they have. I don't know if one of the participants is religious or if all of Florida is taking Yom Kippur off. But for whatever reason, there's not going to be court tomorrow, and that might be because of availability of participants or something. That's fine. So what we're going to do is we're going to save what is happening today, what's happened today, and we're going to watch that on Monday because we won't have anything else otherwise. We're going to catch up that way, and then we'll watch trial on Tuesday. We're going to have something else to filler, probably follow up on some of the cases, maybe if some of our other cases as far as Sarah Boone or Bryan Kohberger or some of the bigger trials that we're watching have updates, even Delphi, that we'll follow those as well on Wednesday. And then we'll be back Thursday and Friday for trial. If we can all be nice and chat. This is a tough case. Very tough case, and people have strong opinions and strong experiences, not just opinions, but literally things that they've lived, and whether they've been on the nursing side, whether they've been on the medical side or a parent side with a child who's had this, or they've got something that's similar to this. Just realize there's some very strong opinions here, and we want to watch this together, but we don't want what some of the other big channels have in their chat, and so I might bring down the ban hammer quite a bit if it's going back and forth and it's not making progress. Just agree to disagree and let it drop, and please be the person who's first to let it drop. We don't need everyone to have to say the final word, but otherwise we're going to have to cut this one short. So Amber, go ahead.
Thank you for that. As a medical professional, some may know, some may not. I myself have a lot of different complex medical conditions. Some I've more recently been diagnosed with, and I'm still trying to become acclimated with. I have been in the same position of being told that pain didn't exist. It was just in my head. There's no real explanation of, why I say I'm having pain other than it's in my head. But it wasn't. Yeah. I have gone through this as a patient and felt how that feels, not having answers, labeled a drug seeker because I've gone in continuing to complain of pain and told that nothing's wrong with you, it's just anxiety or panic disorder, or it's just in your head, we'll send you up to psych. It's a very frustrating thing.
Because it is very real. It's very real. You're the one feeling it, and you're saying, I'm the one that can't sleep because of the pain. I'm the one because that's experienced this, and for someone else to say, because I can't measure it with my devices or with the tests that we have, it must not be real.
Right. So I've been here as a patient, and I'm in medicine to do one thing and one thing only, and that is to advocate as best as I can for patients.
Yeah.
And not everybody does that or knows how to do that as effectively as possible. And this is something I am super, super passionate about. And I want to make something very, very clear. Mandated reporters are not to blame for this case. Mandated reporters have an obligation of reporting suspected child abuse in any inkling, form, or fashion, whether it's the slightest possibility or if it's guaranteed.
When
So,
that mandated, basically the penalty for them not reporting is severe. It's criminal. The penalties for not reporting, even if there's just a suspicion or one or two symptoms show up and you're like, hey, this is on the list that I have to report, and they have to report it. I understand that. It's how you feel about that, and the results that happened, but it's the law. So if you don't like it, we need to change the law, not yell at the people who are trying to follow it.
And that's really there. So it helps to catch those that can't say that they are in a bad situation and need help. So they send out the investigators to investigate to make sure that the kids are okay. And this isn't just for kids. This is also for elderly as well. So keep that in mind too. Mandated reporting is essential to protect anybody who can't necessarily stand up for themselves. You want that option there.
Yeah, we do. Amber, every time you talk, I feel like I'm dragging you out of bed, and you need to be resting.
No, you're fine. You're fine. I'm actually working too. But understand, mandated reporting only goes so far from the person that submitted the report, right? So they have to, by obligation, submit the report of suspected child abuse. After that, it's out of that one person's hands. So please don't blame the mandated reporters that have put in the reports in this case.
Yeah.
And you'll hear more as we get into the case.
We will hear more. And everything we hear is there's no one person's experience has been through this in any way is going to match what we hear in this case. So no matter what you've been through, no matter how it's been, there will be some factors that are a little different in this case. So even if it went one way for you guys, let's just listen to the case. Let's sit through this and discuss it as well as we can, and do it in a friendly way. A kind way, and I think all of us will be better off.
Even if Johns Hopkins All Children's Hospital.
That is that's what we're covering right now, Leslie. And we just finished yesterday's, and we're saving what's happening today. I realize they're visiting today, or they're in court today. We're saving that till Monday because court's closed on Monday. That'll give us something for today. We have a podcast tonight that'll give us material for Monday. We'll be caught up for Tuesday. And so we'll have that testimony on Monday. But Amber, thank you very much. I appreciate that. It's going to be Leslie. Thanks. No, you're good. You're good. We just we got caught up with everything that happened before today, and then what happens today we're going to watch on Monday. But I appreciate that.
Right. I'm going to give a couple more disclaimers if that's okay.
All right.
And then I'll go so I can stop talking. I see people asking about the Netflix documentary. Keep in mind, anytime you watch a documentary, in any case, regardless of what it's about or who it involves, it is very one-sided. So if you watch that documentary, you're going to get a lot of good information as far as what Maya's story is for her medical journey. However, don't just base your opinion on that documentary. It is one-sided. And I come to you with
it's mostly the family's perspective, right?
Right. This is very difficult for me to I have to keep reminding myself to remain objective, right? I cannot let my personal experience affect what my opinion is of this case, because everybody's experiences are going to affect your opinion of any particular case, right?
Yep.
So I'm trying my best to keep that part of it out and stay as objective as possible. So if you don't think you can stay objective after watching the documentary, if you're very easily swayed by one opinion from a documentary, I would actually say don't watch it yet. Wait.
Yeah.
I want to see.
I have not watched it. Mostly because I don't have time, but yeah.
I'm going to ask you not to until we're done with the case, because I think it will taint your opinion of what the case is about. And
I'll say I didn't listen into the jury selection process on this, but I'm willing to bet that if the documentary was out prior to jury selection, which I think it was, that it would have been on there, and had you watched it, you would be ineligible to serve as a jury member. That you'd be excluded because of that. So that's just a thought.
Say that one more time.
I'm willing to bet that if jury members had watched that documentary, they would be excluded from serving on the jury.
Oh, absolutely. 100%. There are things in that documentary that do not meet the rules of evidence for court. And you will not see or hear in this case. And that's imperative for your opinion of this case outcome. So proceed with caution before you watch the documentary. The other thing I'll say is keep in mind, not all the actions and decisions of one typically affect many as far as rules and guidelines. Pain management is a huge problem everywhere, and not everybody has the same opinion on that as far as how it should be managed and controlled, or if it even exists. So understand, not every provider is going to have the same opinion or give the same recommendations or feel the same treatments are applicable to any one particular case.
Yeah,
and every patient is different.
And we're going to hear that in court. We're going to have doctors on both sides that say this is right and the other one's wrong, and we'll hear the flipped one as well. Krista says, thanks for all the prayers earlier. My cousin's out of surgery and doing well. Krista, that is great news. That is wonderful. Thank you so much for sharing. Hope the cousin continues to do well. That is awesome. Amber, thank you for your help. Please get some more rest. We can't wait to have you back to full health and volume and everything else. You sound a little weak right now, so get some rest. Don't push it. Don't push it. Make sure you take care of you. But thank you very much.
I will. I promise, and I'll work on getting you that glossary of terms.
No rush. You work on getting better first, and then we'll talk about it.
I promise.
Okay. Thanks, Amber. Good to hear from you. All right, we'll see you. Bye. Andrew C., member for 5 months, almost 6. Next month you get a yellow courthouse. That says happy to be here. Thank you so much, Andrew. I appreciate that. We are. I'm impressed with this group. I really am. I realize we've got a lot of feelings and things to share, and I look forward to watching this and learning from you all. And I appreciate everyone who's sometimes biting their tongue as I'm learning and making mistakes as I bumble through things, and helping educate me kindly, and give me space and grace to learn at the slow pace that I learn. So thank you very much for all that. What is Monday? Monday, the court is off, but we're going to watch Friday's occurrences, what's going on today on Monday. So that's what we're going to have tonight. We have a podcast, the Not Relevant podcast, Weather Watch and I, who I've got to have words with Weather Watch because he sent me a tropical storm this week and it's hitting us here today. And it was, we were going to go up to Jamestown, and apparently that's where he sent the tropical storm. So we'll have to talk to him about that. But that's all. And anything else we need to cover today? Let's see. The Bryan Kohberger hearings pushed out because of illness, I think. Sherry Smith, thank you. Look at that, 5 months as well. Love my RA family and spending my days here. Wonderful, Sherry. Thank you so much. We've got those pushed out, so we're waiting for the ruling from the judge, Judge John Judge in the Bryan Kohberger case. We could court hop after lunch, but I want to save what happens on Monday to or what happened today for Monday, so we can have a just a good start to the week there, because I like a good solid Monday. Let's see. TLC is me. Look at this. 7 months. Yay, love our family here. Thank you so much, TLC is me. Look at 7 months. You're one of the OGs. You really are. And I appreciate you being here. Would not be the same without you. I think the storm is hitting us here too, says Holly Mack. It's pretty much hitting the whole eastern seaboard. It skipped Florida, right? It sort of went off the coast of Florida, and it's just plowing through the east coast, headed north. So I don't think we have a special guest tonight on the podcast. But we'll be working on some stuff today to make it just enjoyable and fun. We'd like you guys to all join us, of course, in chat, and it's a live podcast where you get to participate that way. It's court hop after lunch. We can do that a little bit. We'll do some court hopping this afternoon, and then we'll get set up. I've got to make better thumbnails and things for this case as we picked it up sort of late. But that's all. That's everything. So lunchtime now. We'll take a break. Give me an hour. How about that? An hour for lunch, and then we'll be back. We'll do a little court hopping, and then we'll be back with this case on Monday as we got up to speed. Debbie says I'm getting sleepy. I was a little sleepy earlier, and you guys caught me just looking at the inside of the eyelids just to make sure they were still there. But I was not falling asleep. I promise. I was watching. Thank you all. Enjoy your lunch as well. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again in about an hour after lunch. Have a great lunch. We'll see you back here in a little bit. Thanks.
I was kicked back, taking it easy.
Scratch all that. Oh, that was terrible. I apologize.
Alex stole it.